Currently serving as the chairman of Standing Committee of Law, Justice and Parliamentary Affairs of Bangladesh National Parliament. As a resource person of today's session, we have with us Honorable Justice Kurian Joseph, former Judge of Supreme Court of India, Mr. Kevin Berry Brown, Course Director of Bangladesh International Mediation Society, Ombudsperson of United Nations and Green Climate Fund IMI, Qualified Assessment Program IMI, Certified Mediation Training Program, President of Mediation International. We have with us Ms. Jamila A. Ali, Senior Counsel, Supreme Court of Guyana and Caribbean Court of Justice. She is a certified mediator, faculty member of Bangladesh International Mediation Society, President of Mediation Services International. We have also Honorable Justice Ahmed Sohel, Judge of High Court Division of Supreme Court of Bangladesh. Ms. Madeline Kimei, advocate as well as an international mediator. Ms. Veera Raghavan Invabichayan is the international arbitrator. Without taking any more time, now I am humbly requesting His Lordship, Honorable Justice Muhammad Iman Ali Sir, more Senior Judge, Appellate Division of Supreme Court of Bangladesh and recipient of International Mediation Award, to discuss mediation under Bangladesh law.
Thank you, Olindita. Good morning, Assalamu alaikum, good afternoon, wherever you may be. Welcome to everyone. If I may share my screen. Hold on, let me just see how to do this. I've done this so many times, but I still wonder how to do it. Okay, here we go. That should do. Can you see my screen? What do you see?
Sir, your screen.
And in the screen is the PowerPoint.
Yes, sir.
Nothing else?
No, sir.
Good. I don't want you to see my desktop because it's all messy. Okay, you will excuse me if I occasionally take a sip of my tea because I have some little problem with my throat. So occasionally I will take a sip of the tea. Now, welcome everyone. This is our real attempt. I said in the slide, this is our first real attempt, but that was 2 attempts ago because our first one was with the division in Rangpur. The second one was with division in
Rajshahi.
And the third one this time is Barishal. Thanks to BIMS for creating this opportunity, because it is a unique opportunity for us all to know a bit more about mediation, which is something we have discussed about it yesterday. It's something which is ages old, thousands of years old, if not hundreds of years old as we know it. Yesterday, I spoke about my own personal knowledge of mediation when I was a child. We thank the judges who are participating as trainees. We thank also the judges and other faculties who are going to be telling us all about mediation. I know very little about mediation myself, but what I would like to do is to tell everyone the laws relating to mediation in our country so that the judges can be aware. I'm sure they all know where the law is, but I want to go into a little bit more detail of exactly what the law says so that we are perfectly clear. By the end of today, we should know exactly where the law is and precisely what the law says. Now, I've said already that this is a different path that we are not used to because the scheme has not been really propagated well enough up to today. And also, we do not have all the facilities, the infrastructure in place as yet. But I can assure you that slowly we shall get there. I hope sooner than later. Let me just tell you about something that Sriram Panchu is a very famous mediator and also has written several books on this issue. In his preface to the first edition, he said, "At first, people refuse to believe that a strange new thing can be done. Then they begin to hope it can be done. Then they see it can be done. Then it is done, and all the world wonders why it was not done centuries ago." Now, we have to say that mediation had been done from centuries ago.
It's just that our court system, the mediation system in our courts, or court mediation, if you want to put it that way, has not been in vogue, has not really become popular as yet. The court mediation is therefore quite recent. Now, yesterday, I told you about the good news that we are issuing a circular from the Supreme Court to tell all the judges about all the laws that are already in place to allow for mediation. And also that soon we hope to put out guidelines setting out what the judges must say to the parties when referring the case to mediation, and particularly to explain the benefits and attractions for mediation rather than going through the process of litigation in the courts. The great news. I said I would tell you some great news. I want to read out precisely what the circular might say. I have to tell you, and I have to
request you, please don't copy this out yet, because it is only in draft. As it says there, it is draft, and therefore it is not yet known to the world. You are the first persons to see it. This is not the final version. This will not be the final version. This is just a draft, but I'm just showing you so that you know what is going to be there, hopefully. আমি পড়ে যাচ্ছি। অধস্তন দেওয়ানি আদালত এবং অর্থঋণ আদালত সমূহে কোনো মোকদ্দমায় বিবাদী কর্তৃক লিখিত জবাব দাখিলের পর the Code of Civil Procedure এর 89A ধারা এবং অর্থঋণ আদালত আইন 2003 এর 22 ধারার বিধান মতে মধ্যস্থতার মিডিয়েশন মাধ্যমে বিরোধ নিষ্পত্তির লক্ষ্যে মধ্যস্থতার উদ্যোগ গ্রহণের বাধ্যবাধকতা রয়েছে। কোড সেকশন 89C ধারায় উক্ত কার্যবিধির 41 আদেশের অধীনে মূল মামলার ডিক্রির বিরুদ্ধে দায়েরকৃত আপিল সমূহ নিষ্পত্তির ক্ষেত্রেও মধ্যস্থতার পন্থা অবলম্বনের নির্দেশনা রয়েছে। এছাড়াও আরবিট্রেশন অ্যাক্ট 2001 এর 22(1) ধারায় এবং বাংলাদেশ শ্রম আইন ধারা সহ অন্যান্য আইনেও মধ্যস্থতার মাধ্যমে বিরোধ নিষ্পত্তির বিধান রয়েছে। So just for the benefit of those who are not able to understand Bangla, very simply put, is that we are telling everyone, all the judges particularly, because this is going out to the judges of all the districts of Bangladesh, that mediation is mandatory under the provisions of Section 89A of the Code of Civil Procedure, as well as under Section 22 of the Orthorin Adalot Ain, and not mandatory but otherwise applicable discretionary in other laws, including the Arbitration Act and the labor laws. The second clause, সম্প্রতি লক্ষ্য করা যাচ্ছে, this is important, I would like the judges to make sure that they realize this, সম্প্রতি লক্ষ্য করা যাচ্ছে যে অধস্তন অনেক দেওয়ানি আদালত, দেওয়ানি আপিল আদালত এবং অর্থঋণ আদালত মধ্যস্থতা সংক্রান্তে দেওয়ানি কার্যবিধির 89A এবং 89C ধারার এবং অর্থঋণ আদালত আইনের 22 ধারার বিধানাবলী যথাযথভাবে অনুসরণ করছেন না। এই বিধানাবলী প্রয়োগ না করার কারণে দীর্ঘসূত্রিতার মাধ্যমে একদিকে যেমন মামলা জট বৃদ্ধি পাচ্ছে, অন্যদিকে আপিল ও রিভিশন মামলার সংখ্যাও সমান হারে বৃদ্ধি পাচ্ছে। ফলে বিচারপ্রার্থী জনগণের সময়, শ্রম ও অর্থের অপচয় হচ্ছে। If I can just very briefly translate that, it's simply saying that it is seen that the courts are not applying the provisions of the laws that মাধ্যমে নিষ্পত্তির উদ্যোগ গ্রহণ করতে হবে। So there is the mandate that you must implement the provisions of Section 89A and 89C, both at the trial and the appellate level. আইন এছাড়াও 210 ধারা সহ সংশ্লিষ্ট অন্যান্য আইনেও মধ্যস্থতার মাধ্যমে বিরোধ নিষ্পত্তি যে বিধান রয়েছে তা যথাযথভাবে প্রতিপালন করতে হবে। অধস্তন দেওয়ানি মোকদ্দমা নিষ্পত্তি করা সমীচীন মর্মে সুপ্রিম কোর্ট স্পেশাল কমিটি ফর জুডিশিয়াল রিফর্মস ইতোমধ্যে মতামত প্রদান করেছে। মধ্যস্থতার মাধ্যমে নিষ্পত্তি করা হলে দেওয়ানি মোকদ্দমা দ্রুত নিষ্পত্তি সহ আপিল ও রিভিশনের সংখ্যা কমবে এবং মামলা জট হ্রাস পাবে। যেটা আমি কালকে বলেছিলাম যে দ্রুত এই মিডিয়েশনের মাধ্যমে নিষ্পত্তি হলে এই মামলার আর কোনো আপিল হয় না এবং কোনো রিভিশন হবে না, ফলে মামলাটা এইখানেই শেষ হয়ে যাচ্ছে। এবং বুঝতেই পারছেন যেখানে দুই পক্ষ মিলে একটা চুক্তি করে, চুক্তিতে রাজি হয়ে যায়, টার্মস এন্ড কন্ডিশনস ঠিক করে নেয়, তখন এর বাইরে যাওয়ার আর কোনো স্কোপ নাই। 4 নম্বরে আছে উল্লেখ্য যে কোড 89A(1) ধারার বিধান অনুযায়ী মধ্যস্থতা মিডিয়েশনের মাধ্যমে নিষ্পত্তির জন্য আদালত শুনানি মুলতবি রেখে নিজেই মধ্যস্থতা করবেন কিংবা পক্ষগণের আইনজীবী বা আইনজীবীদের নিকট অথবা আইনজীবী নিযুক্ত না হয়ে থাকলে পক্ষ বা পক্ষগণের সম্মতিতে উপধারা 10 অনুসারে জেলা জজ কর্তৃক এতদুদ্দেশ্যে প্রণীত প্যানেলের কোনো মধ্যস্থতাকারীর নিকট মোকদ্দমাটি মধ্যস্থতার জন্য প্রেরণ করবেন অথবা আইনগত সহায়তা প্রদান আইন 2000 এর 21(ক)(1) ধারার অধীন নিয়োগপ্রাপ্ত লিগ্যাল এইড অফিসারের নিকট প্রেরণ করবেন। এছাড়াও অর্থনীন আদালত আইন 2003 এর 22(2) ধারা বিধান অনুযায়ী মামলার পক্ষগণের পারস্পরিক সম্মতির ভিত্তিতে কোনো পক্ষ কর্তৃক নিয়োজিত নয় এমন একজন আইনজীবী অথবা কোনো অবসরপ্রাপ্ত বিচারক, ব্যাংক বা আর্থিক প্রতিষ্ঠানের অবসরপ্রাপ্ত কর্মকর্তা অথবা অন্য যে কোনো উপযুক্ত ব্যক্তিকে মামলা নিষ্পত্তির উদ্দেশ্যে মধ্যস্থতাকারী মিডিয়েটর হিসেবে নিযুক্ত করা যাবে। So the law tells us in 89A subsection 10 who can be appointed mediator. There will be a panel of mediators to be made by the district judge in consultation with the president of the District Bar Association. এমতাবস্থায় অধস্তন দেওয়ানি আদালত এবং আপিল আদালত সমূহকে The Code of Civil Procedure 89A, 89C ধারা, অর্থনীন আদালতের 22 ধারা, Arbitration Act 22 এর 1 ধারা, বাংলাদেশ শ্রম আইনের 210 ধারা সংশ্লিষ্ট অন্যান্য আইনে মধ্যস্থতার মাধ্যমে বিরোধ নিষ্পত্তির যে বিধান রয়েছে তা যথাযথভাবে প্রতিপালনের জন্য নির্দেশ প্রদান করা হলো। So যথাযথভাবে প্রতিপালনের জন্য নির্দেশ প্রদান করা হলো। The Supreme Court is therefore directing the judges to make sure they implement the mandatory provisions of the law as well as the discretionary provisions where the discretion is exercisable. একই সাথে কোডের 89A 10 এর উপধারার বিধান অনুযায়ী দেশের সকল জেলার জেলা জজগণকে সংশ্লিষ্ট জেলা আইনজীবী সমিতির সভাপতির সাথে পরামর্শক্রমে মধ্যস্থতাকারী মিডিয়েটরগণের একটি হালনাগাদ তালিকা প্রস্তুত করে পত্র কোর্টে প্রেরণ করার জন্য নির্দেশ প্রদান করা হলো। Again, there is a direction upon the district judges to make sure that a panel of mediators is created in consultation with the presidents of the bar associations and that now must be forwarded to the Supreme Court. Again, it is a mandate of the law. It must be done. It hasn't been done. We know that it has not been done by many districts. I don't know how many, if there may be any, probably very few districts which have actually implemented this provision of the law. এই সার্কুলারের কোনো নির্দেশনাবলী অনুসরণে কোনো সমস্যা বা প্রতিবন্ধকতা দেখা দিলে বা কোনো বিচারক কর্তৃক কোডের 89A, 89C ধারার এবং অর্থনীন আদালতের 22 ধারার বিধান সহ মধ্যস্থতা সংশ্লিষ্ট অন্যান্য আইনের বিধানাবলী প্রতিপালনে অনীহা বা গাফিলতি পরিলক্ষিত হলে বিষয়টি অত্র কোর্টকে অবহিত করার জন্য স্থানীয় নিয়ন্ত্রণকারী কর্তৃপক্ষকে অনুরোধ করা হলো। So there is the situation. You are bound to implement the law as it is. Particularly make sure that you implement the mandatory provisions, failing which you will be taken to task, I can assure you. And we want you to do this sincerely with a view to making sure that the law, first of all, the law must be implemented. Secondly, keep in mind that this is for the benefit of the litigant public. The laws are made for the public. And if the public do not get the benefit of the law, then we are failing in our task. As I said, the guidelines will follow, but what will the guidelines say? Go and try mediation. If you don't succeed, come back. That is not what the guidelines will say. That is certainly not what the judges should tell the parties who are being sent for mediation. What they should be told is that mediation process in these particular cases is mandatory, therefore it must be done. There is no compulsion to complete the mediation. Now here we drew the distinction, as we said yesterday, that to send to mediation is mandatory. To go through with the mediation is voluntary. So a party can say at any stage during the mediation process, no, that is enough. I do not want to do any more mediation. I want to go back to the court. The court will decide. They are at liberty to do that. But to send the case for mediation after the written statement is filed, that is mandatory. The court has to adjourn the case for the purpose of sending it for mediation. What I may suggest, and this is just a suggestion because the law does not say it, is that once the written statement is received, you fix a date and say, on that date, the case will be sent for mediation, because you have to have an opportunity to tell the parties that what you are going to do, what you expect to achieve through this mediation. Parties must be told that they can choose their mediator. Now, who can be mediator? Mediator can be the judge himself. That is the court mediation. Or mediation can be done through the legal aid officer. In both of these cases, the party must be told that there will be no cost for the mediation, because these are officials of the court who are already being paid their salary. They can't charge for the mediation. On the other hand, the party may choose to go for someone to mediate from the mediators panel, created under subsection 10 of section 89A. Or the parties may choose their own mediator. Mediation by the court or legal officer is no cost. I've already said cost of mediation can be obtained from the legal aid fund. The other things that must be told to the parties is that the mediation process is confidential. Anything said, discussed, or shown at the time of mediation will not go back to the court. Because very often we find that parties are very sensitive to saying things because it might go against them, or they fear that it might go against them. But here in mediation, they can confidently tell the mediator or the other party things which they would otherwise not disclose. But bear in mind one hurdle that the objection that may be raised, and that is, Priyanka, I think, mentioned yesterday that some parties may use this mediation scheme to obtain information, stop the mediation, and then use that information for the suit itself. Although they should not go back, the information must not go back to the court, but already you have disclosed to the other side maybe some information which can be used. The mediation process is informal, so you are not in court. Unlike any court or arbitration, the parties can talk. In fact, mediation, as we heard yesterday, is the scheme where only the parties talk. The mediator doesn't speak much, only speaks to enable the parties to continue their conversation. His duty is to make sure that the parties talk, discuss, and decide what is best for them. Mediator listens. That is the main purpose of the mediator. He listens patiently and then allows the parties to discuss their difficulties, discuss the hurdles that each is facing, and discuss what will be the best solution for their case. It is the parties who decide the best solution for their case. It is the parties who will decide the terms and conditions if they come to an agreement. The parties are in control of the whole process of mediation. Another very important aspect of mediation, which must be told to the parties. Otherwise, why should they go to mediation? Why should they stay with mediation? The reason is that it is very speedy. The time of the mediation is bound by the law. The mediation must be completed within 60 days from the time of fixing the mediator. If both parties agree, or on suo motu application by the court, the period of 60 days may be extended by only 30 days more. So within the 90 days period, mediation must be concluded. Whereas trials take months, sometimes years, in fact, most often years and years, decades. And once the agreement is reached, mediation, the agreement will be sent to the court for decree, and the court must pronounce the decree within 7 days from there, maximum period. And next important thing, it is less expensive. Obviously, it is less expensive. Number one, if you go through the legal aid process, then of course it is least expensive. But even if you do not qualify for legal aid, it is still less expensive because it takes lesser time, and less time of engagement of lawyers is obviously less costly. So no cost if it is done by the court itself or by the legal aid officer. If the parties reach the agreement, that will end up as a decree, and there is no appeal or revision against that. And obviously, that is so because it is the parties who have decided. They will have decided to cut their losses. Yes, instead of getting 10 lakhs today, 20 lakhs tomorrow, or next year or the year after by installments, if somebody agrees to receive 10 lakhs today, that is good for both sides. One side saves 10 lakhs, the other side gets 10 lakhs today and saves the worry for the next so many years and whether or not he or she will not get the installments. As we heard yesterday from Justice Geeta Mittal, a bird in the hand is worth, the saying is 2 in the bush, but she said 10 in the bush, which I think is probably more appropriate in this case. Agreement reached. This is again a very important aspect. If agreement is reached through the mediation, then by law, the court fees will be refunded. So again, gain for the litigant parties. And most importantly, I think, is that mediation leads to peace. Arbitration, litigation leaves a bad taste in the mouth. One party wins, another party loses. One party is laughing, only momentarily, I tell you, and the other party is crying. But be assured, party who wins has not won yet, because there is always the rest of the process of execution. Moreover, he will know that the other party will go to appeal and revision and to the appellate division. So it is not the end. Whereas mediation is the end. That is final. You both agree, you both shake hands, and you live your life as before. Same relationship. Whereas litigation, arbitration, you win and you become an enemy. So you don't win. You lose, the other side is the enemy. So nobody wins. Mediation, as we heard yesterday, is win-win. Now, the sources of mediation can be terms of a contract, and therefore automatically it will go to mediation. Mediation by the legal aid officer Yesterday, we heard Justice Geeta Mittal tell us about pre-trial mediation. We don't have in our law in section 89A or C any process of mediation before the trial commences, because by law here, mediation commences at the time of filing of the written statement. And as she quite rightly said yesterday, I respectfully agree with her, that at that stage, when the person has already responded to the plaint, then they are all ready to fight. Parties are at loggerheads. One party says this, other party says that, and they're in a fighting mood. If the thing could be mediated before that, of course, they would be possibly in a better mood. But then our law does not allow for such provision. On the other hand, the legal aid officer is in a much better position, because the person who is concerned about whether or not he has a legal right, he goes to the legal aid officer first. One thing we have to do is make sure that people understand and realize that they can go to the legal aid officer. If and when they do, the legal aid officer's duty is to first of all assess whether there is a case to answer, whether he has a case at all. If the legal aid officer is satisfied, now legal aid officer is, as you all know, an assistant judge. A judge, nevertheless. Young judge, true, but he is a judge, is a qualified judge. That is something that the public must be made to understand. The judge is saying, yes, you have a case to answer. There is a case, but first mediation. So here we get the provision of mediation before any trial actually commences. The legal aid officer will write to the other side, the defendant, invite him for mediation. If he agrees, then the mediation process starts and the whole thing can be concluded here in the legal aid officer's office. If parties agree, come to an agreement, then they each sign. The officer, mediator, signs as the witness, and this goes to the court for decree. The ordered by the court, mandated, that is again repeating myself, under section 81A and 89A and 89C, and ordered by the court when it is discretionary if the parties agree. Section 89A of the code, if I can just read you the relevant portion, again, the whole scheme begins after filing of written statement. If all the contesting parties are in attendance in the court, in person, or by their respective pleaders, the court shall. Now that was introduced in the year 2012. Before, in 2003, mediation was introduced by adding section 89A. Then it was, at that time, it was discretionary, as it is still in India, discretionary. But here in 2012, it was made mandatory. So the court shall, by adjourning the hearing, so the court shall adjourn the hearing, mediate in order to settle the dispute or disputes in the suit. Mediate. That means the court can mediate. Excuse me, let me just have a sip. So the court can itself mediate in order to settle the disputes, or refer the dispute or disputes to the concerned legal aid officer appointed under the Legal Aid Act of 2000, or they can send tell the lawyers, the engaged pleaders, or the parties, where no pleader is available, then just to the parties, to meet and send the matter to a mediator from the panel, as may be prepared by the district judge under subsection 10 for undertaking efforts for settlement through mediation. This is the law. You can all read the law. It is there in black and white. I'm just highlighting what is there. Section 89C. Section 89C says this: an appellate court shall mediate in an appeal or refer the appeal for mediation in order to settle the dispute or disputes in that appeal if the appeal is an appeal from original decree under Order 41. And is between the same parties who contested in the original suit. You please excuse me just for one moment. Sorry about that, please excuse me. So I was on section 89C. So as Justice Geeta Mittal said yesterday, I can only repeat, if the mediation is mandatory at the appeal stage, then I also believe that mediation can be done at any stage during the trial. So not just simply at the stage of written statement. If, for example, the parties fail to mediate on the first occasion, they come back to the court. If after taking further evidence, it appears that this is the case which can be mediated, the court can again send it. Or if the parties decide that, yes, we will go for mediation, it can go again back to mediator. And then section 89D is a provision which allows the parties to agree. So if the case was filed before 2012, when the mediation was not mandatory, discretionary, but now that the law has been passed making mediation mandatory, even though the case was filed before it was mandatory, the parties can now agree to go for mediation under section 89 capital D. Section 22 of the Orthorin Adalat Ain. Again, after filing of written statement, let me just read to you what it says. চতুর্থ পরিচ্ছেদে বর্ণিত সাধারণ পদ্ধতিতে মামলার বিচার ও শুনানি সম্পর্কিত যে বিধানই থাকুক না কেন, এই আইনের অধীন দায়েরকৃত কোনো মামলায় বিবাদী কর্তৃক লিখিত জবাব দাখিলের পর আদালত ধারা 24-এর বিধান সাপেক্ষে মধ্যস্থতার মাধ্যমে বিরোধ নিষ্পত্তির লক্ষ্যে মামলাটি নিযুক্ত আইনজীবীগণ কিংবা আইনজীবী নিযুক্ত না হইয়া থাকিলে পক্ষগণের নিকট প্রেরণ করিবে। So again, at the stage of filing of written statement, the court will either hand back the case to the parties to go for mediation, or if they have engaged a lawyer, to the lawyer to go for mediation. And who will do the mediation in the case of Orthorin Adalat Ain? Subsection 2 tells us, উপধারা 1-এর অধীন প্রেরিত মামলায় নিযুক্ত আইনজীবীগণ মামলার পক্ষগণের সহিত পরামর্শক্রমে পারস্পরিক সম্মতির ভিত্তিতে অপর একজন আইনজীবী, in other words, it has to be, of course, an independent lawyer, not a lawyer engaged in the particular case. অপর একজন আইনজীবী যিনি কোনো পক্ষ কর্তৃক নিয়োজিত নহেন, অথবা কোনো অবসরপ্রাপ্ত বিচারক, ব্যাংক বা আর্থিক প্রতিষ্ঠানের অবসরপ্রাপ্ত কর্মকর্তা, অথবা অন্য যে কোনো উপযুক্ত ব্যক্তিকে মামলা নিষ্পত্তির উদ্দেশ্যে মধ্যস্থতাকারী হিসেবে নিযুক্ত করিতে পারিবেন। তবে সরকারি কোনো চাকরিজীবীকে এঙ্গেজ করা যাবে না। সেকশন 38 of the অর্থঋণ আদালত আইন also relevant. এই আইনের অধীন অর্থঋণ আদালত মামলায় প্রদত্ত ডিক্রির ধারাবাহিকতায় জারি কার্যক্রম অব্যাহত থাকার যে কোনো পর্যায়ে, so in the CPC we had at the appeal stage it can be done. এইখানে বলছে জারির পর্যায়ে পক্ষগণ মধ্যস্থতার মাধ্যমে জারি মামলার বিষয়বস্তু নিষ্পত্তি করিয়া আদালতকে অবহিত করিতে পারিবে। So it is not mandatory, it is discretion, but it can be done even at the stage of execution of a case, of a decree. And then we have section 44 co of the অর্থঋণ আদালত আইন। সপ্তম পরিচ্ছেদের অধীন আপিল বা রিভিশন কার্যক্রম অব্যাহত থাকার যে কোনো পর্যায়ে, so here we have the similar version for 89C, যেখানে সিভিল প্রসিজার কোডের আন্ডারে আপিলের সময় বাধ্যতামূলক। এইখানে যে কোনো পর্যায়ে পক্ষগণের মধ্যস্থতার মাধ্যমে আপিল বা রিভিশন মামলার বিষয়বস্তু নিষ্পত্তি করিয়া আদালতকে অবহিত করিতে পারিবে। So here there is no mandate, but discretion is there. Even at the execution stage, even at the appeal and revision stage, there can be mediation if the parties agree. Arbitration Act section 22 was that at any time during the arbitration, if both parties agree, there is a discretion to mediate, compromise, etc. And there will be an agreed award. So I usually tell you this, that means, of course, that mediation is a better form of alternative dispute resolution, even better than arbitration, because the Arbitration Act itself says, go for mediation. Obviously, that means that mediation is better, more attractive than arbitration. And I think it goes without saying that mediation is better because it takes less time. Arbitration takes years. I told you yesterday about a case which we decided last week. After 17 years, we found that the arbitration was not done within the law. The notice had not been sent to the party in accordance with the law. And once that is proved, the whole process of arbitration was based on an illegal, unlawful foundation. After 17 years of arbitration, the matter falls through, they go back to the drawing board, again start arbitration. Whereas mediation, there is no such provision. There is no such difficulty because mediation is here and now. Parties discuss, parties talk, parties decide. And that is the end of the matter, once and for all. Again, we have the provision of mediation in the labor law, which you can see from the law itself. Other laws, the section 17(1) of the Small Claims Courts Act, the one thing that has been said that it looks like mediation under the Family Laws Ordinance, Family Courts Ordinance, but I personally don't think it's mediation. It's rather conciliation, arbitration, but not mediation as such. And also the Code of Civil Procedure does not apply. And therefore, I will say that it is not mediation, but nevertheless, it is a process which is working, which is allowing persons, litigants to do away with further litigation simply by going to the court and getting their dispute done and resolved through this mediation or through this conciliation and arbitration process under the Family Laws Ordinance. Mediation by legal aid officer, I've already spoken about. Now here, কি বলছে? বিষয় বা প্রসঙ্গত পরিপন্থী কোনো কিছু না থাকিলে এই আইনে কোড অফ সিভিল প্রসিজার 1908 এবং প্রচলিত অন্যান্য আইনের বিধান অনুসারে মধ্যস্থতা বা সালিশের মাধ্যমে কোনো মামলা নিষ্পত্তির উদ্দেশ্যে নিযুক্ত মধ্যস্থতাকারী বা সালিশকারীকে সম্মানী প্রদান, so if there is a mediation by some other person, then the legal aid officer is empowered to provide the fees. আইনজীবীকেও সেই ফিজ প্রদান করা যাবে। লিগ্যাল এইড অফিসার আইনগত সহায়তা প্রার্থীকে আইনে পরামর্শ প্রদান করিতে পারিবে এবং প্রচলিত আইনের অধীন কোনো আদালত বা ট্রাইব্যুনাল কর্তৃক উহার স্থানীয় অধিক্ষেত্রের আওতাধীন এলাকার কর্মরত লিগ্যাল এইড অফিসারের নিকট বিকল্প পদ্ধতিতে বিরোধ নিষ্পত্তির জন্য কোনো বিষয়ে প্রেরণ করা হইলে উহা নিষ্পত্তির ক্ষমতা সংশ্লিষ্ট লিগ্যাল এইড অফিসারের থাকিবে। So this is the referral from the court. The court refers to the legal aid officer. The legal aid officer is within his power to deal with the mediation. The rules provide the details of the procedure. If there is a case to answer, then he will advise for mediation. If the defendant agrees to mediate, the legal aid officer takes steps. He will then preside the mediation, and there the law says. And one question that was previously asked is that the assistant judge has a pecuniary jurisdiction under civil law. The what is the Courts Act, if I'm not mistaken. But whatever, the limitation is with regard to hearing of cases, suits. That limitation does not apply when it is done through mediation, because mediation, the judge is not a judge. In mediation, the judge does not judge. That is very clear. We heard that yesterday. He is simply a person who sits in the middle. He's a referee. He stops the people fighting, but gets the people talking. That's the idea. And for that, there's no question of any pecuniary limit. Who can be a mediator? Well, I think we have already covered most of it. Judge himself, legal aid officer, or the person agreed upon by the pleaders or the parties. Only I can't be a mediator because I am already salaried. Persons holding the office of profit in the service of the Republic cannot become mediators. The panel, we hope that after the circular goes out, it will be copied to the, of course, to the judges and also to the presidents of the district bar associations. And hopefully that will encourage them to create the panel as is required by law under subsection 10 of section 89A. The duty of the judge, we have already spoken. This is what he's going to do. Explain. No compulsion to conclude mediation, parties can choose mediator. I won't repeat that. Fees of the mediator. If the mediator is the court itself or the legal aid officer, no fees. Other mediators, fees and procedure agreed upon by parties. Failing that, the court shall fix the fees. That is under section 89A, subsection 3. If the court fails to mediate, back to the court, but this time another judge will deal with the suit litigation. That is under subsection 9 of section 89A. And this is something that was mentioned yesterday, that Priyanka, I believe, mentioned this, and here it is in our law. The judge who referred the case to mediation cannot hear it. If he fails to mediate, then it will go to the court and it will be heard by, the litigation will continue, but through another judge. Appointment of mediator, section 89.4, appoint and notify within 10 days from reference. So here again, time bound. Within 10 days, it must be notified to the court. In default, the court shall appoint from the panel in 7 days thereafter. So everything happens like clockwork. It's like a machine. If this happens, that will happen. If that happens, something else will happen. So all the time frame is fixed. As a result, mediation is the speediest form of dispute resolution. What we have said before already, mediation to conclude within 60 days from appointment and 30 days on joint application, or court suo motu can grant the 30 days. 89A subsection 5, report result to the court, terms of the compromise in the form of written agreement with signatures or left thumb impressions of the parties, signatures of pleaders and mediators as witness. Within 7 days, the court shall pass order to record the agreement, compromise, or satisfaction of the plaintiff and pass decree under order 23, rule 3 of the code. And I've already said, refund of court fees. If there is an agreement through mediation, court fees are refunded. Appeal revision, no appeal or revision against the order of decree of the court, which is achieved through mediation. And this is the attraction. It is an agreed settlement. And once you agree a settlement, you cannot go back. And usually there is no scope for any further dispute because you have decided, you have cut your losses. I think I have come to the end of my slides, have I? Looks like it. No, maybe not. There's some more. Mediation characteristics. Explanation 1 to subsection to section 89A. Mediation shall mean flexible, informal, non-binding, confidential, non-adversarial, and consensual dispute resolution process. The law itself tells you what it is. The mediator shall facilitate compromise without directing or dictating the terms of such compromise. Not non-binding, as we tried to explain yesterday, does not mean that the decree or order is not binding. That is binding. There is no appeal or revision against that. But the process is not binding. In other words, you can go to the mediation room and you can say, sorry, I don't want to mediate. I want to go back to the court. The judge will decide. Appellate court we've already talked about. Arbitration Act we've talked about. Ortoron Adalat Ain we've talked about. Again, here is the time limit in Ortoron Adalat Ain. Mediation within 30 days, 60 days, and then additional 30 days. Order of decree in terms of the written agreement. Successful mediation means refund of court fees. So that extraction must be told to the parties. Suit must be disposed of within 90 days plus 30 days from the written statement, including mediation. So here again, the quickest way to dispose of the case. Arbitration takes months. And if the parties so desire, they can drag it on for years. And at the end of the day, you get nothing. Whereas in mediation, it is disposal, is final, and no appeal or revision. Mediator's job is to listen, and at the end of the day, both parties come to a happy conclusion. But what we need is awareness building. And this, I hope, as soon as you go from this conference, this training session, you will impress upon your colleagues what you have heard. The lawyers must be aware of the benefits of mediation. The problem we find with the lawyers, because they think they're losing out their case. They're losing out their cow which gives them milk every day they appear in the court. But hopefully we will soon try to bring them on board to try to appreciate that this is a method of dispute resolution which will be in the long run beneficial for them also, because it will take lesser time to dispose of cases and bring them more and more income. That is what they are worried about. The judiciary must be aware. The public must be aware. And we have suggested that publicity about mediation, about the speed and the cost saving, the simplicity, the informality, the confidentiality, all these things bear upon the litigant public. They worry about these things. So if they can be assured about these problems, then they will come from mediation. And the way to bring awareness, I suggest TV, because that is probably the most used medium these days, particularly in the rural areas. And social media, everybody uses Facebook. So even sort of cartoon type of effort can be put out into the public domain to show what mediation is, what mediation does, and what mediation can achieve. Last but not least, thank you for your attention and good luck. But before I finish, I have a few minutes left. Let me tell you a very small story. I became a mediator, not intentionally, last week. I have two cousins, distant cousins, from the same village, both living in the UK. So they had apparently decided by themselves, it came to an agreement that one should sell to the other her property in their home district. And the price was, let's say, 30 lakhs. So the purchaser paid 23 lakhs there and then, and subsequently paid another 4 lakhs. So altogether, 23 lakhs was one-off, and then small installments paid another 4 lakhs. So 27 lakhs paid. 3 lakhs remained unpaid. In the interim period, they decided, আমি বাংলায় বলি, যে যে কেনার কথা ছিল সে ভাবলো যে বোধহয় এটা কি গুড ভালো ডিল হচ্ছে নাকি, যদি প্রবলেম হয় কি করব, একটু আমতা আমতা ভাব। এতগুলা টাকা দেওয়ার পরে এইটা দেখে আদার সাইড বললো কি, নিবানা যখন তাইলে ঠিক আছে, ফরফিট করে ফেলবো টাকা। গেল তারা, একজন ধনাঢ্য ব্যক্তি, দুজনেরই পরিচিত, ওনার কাছে যাওয়ার পরে উনি কি বললেন, উনি আবার একটা সাইড নিয়ে নিলেন, ওনার একটু ক্লোজ হয়, উনি ওই সাইডকে বললেন যে তোমরা এতদিন টাকা দেয় নাই, তোমরা এতদিনের ভাড়া চাও তার কাছে, 11 লাখ টাকা ভাড়া হয়ে যায়, এগুলা চাও, কারণ তোমার বাকি টাকা না দেওয়াতে, রেজিস্ট্রি করে না নেওয়াতে তোমার যে এই ক্ষতি হইলো, এই ক্ষতিপূরণ 11 লাখ টাকা চাও। এখন যে কিনবে সে ভাবলো যে 11 লাখ টাকা কেন দিব, এতগুলা টাকা দেওয়ার পরে উনি দখল দিয়ে দিয়েছিল। তারপরে এখন ওর ভাড়া কোথায় লাগলো না লাগলো এটা আমাদের কি, আর এই 3 লাখ টাকা বাকি আমরা তো যখন তখন দিতে এখন রাজি আছি। তো কোন এক ফাঁকে মাঝখানে এই যে কিনবে সে বলেছিল ঠিক আছে, ওই আমরা নিয়ে নিব, এখনই টাকা দিয়ে দিব, নিয়ে নিব, কিন্তু আমার নামে রেজিস্ট্রি করে না দিয়ে আরেকজনের নামে রেজিস্ট্রি করে দিতে হবে। ওরা আবার যে বিক্রি করবে তারা জেনে গেছে যে এই আরেকজন তাকে যে দাম ঠিক করা হয়েছিল এর চেয়ে অনেক বেশি দিতে রাজি আছে, যার জন্য তৃতীয় পক্ষকে দিতে বলছে। এখন এ বলছে যে না, দেব না, তোমার সাথে চুক্তি ছিল, তোমাকে দেব, আরেকজনকে দেব কেন? আমি, তুমি টাকা ফেরত নিয়ে নাও, আমি বিক্রি করবো না তোমার কাছে আর। এই পর্যায়ে আমার কাছে আসছে, দুজনেই আমার আত্মীয় হয় দূর সম্পর্কে, তো যে কিনবে সে আসছে আমার কাছে, এখন কি করে, আমরা টাকা দিতে চাই, ওরা তো এখন টাকা নিতে রাজি না, আর বলছে যে আরো 11 লাখ টাকা দিতে হবে এক্সট্রা। তখন আমি বললাম যে মধ্যস্থতাকারী এই যে মাঝখানে কে বলছিল, তখন চিনতে পারলাম আমি, এবং সে খুব লোভী লোক। সে বলছে 11 লাখ টাকা দিতে বলো, নাহলে বিক্রি করো না, তোমরা আর অনেক ভালো দামে এখন বিক্রি করতে পারবা। তখন আমি আমার অপর কাজিনকে ফোন করলাম, আমি বেশি কিছু বলি নাই, শুধু বলেছি যে তোমাদের একটা কেনা বেচা নিয়ে কি সমস্যা হচ্ছে, বলো তো কি অবস্থা, কি সমস্যা। তখন এরা আমাকে বলল যে সমস্যা হচ্ছে যে তারা টাকা তো এতদিন দেয় নাই, আমাদের অনেক লস হয়েছে, আমরা সেই রেজিস্ট্রি করে দেওয়ার জন্য পাওয়ার অফ অ্যাটর্নি সব দিয়ে দিয়েছি, অনেক টাকা খরচ করেছি, তারা টাকাটা দিয়ে দিলে আমরা তখনই দিয়ে দিতাম, এখন আমরা বলছি যে আমাদের ক্ষতিপূরণ দিতে হবে, 11 লাখ টাকা দিতে হবে। এর মধ্যে তার হাজবেন্ড ছিল পেছনে, সে বলছে 11 লাখ টাকা দিব না। উনি বলছে যে ওনার আরেকজনকে দেওয়ার জন্য, আরেকজনের নামে রেজিস্ট্রি করে দেওয়ার জন্য সে, আমরা শুনেছি 95 লাখ টাকা দিচ্ছে। এখন আমাকে 95 লাখ টাকা দিলে আমি দেবো, আদারওয়াইজ আমি দেবো না। তো কিভাবে কমপ্লিকেটেড হয়ে গেল জিনিসটা? তখন আমি জিজ্ঞেস করলাম যে তোমরা তো চুক্তি করেছিলাম। হ্যাঁ করেছিলাম। কত টাকায়? 30 লাখ টাকায়। কত টাকা তখন দিয়েছিল? যে 23 লাখ দিয়ে দিছে। বাকি আরো পেয়েছো? হ্যাঁ আরো 4 লাখ টাকা পেয়েছি। সো there is no dispute. বেসিক্যালি এখানে কোনো কেউ মিথ্যার আশ্রয় নিচ্ছে না। টাকা যে পেয়েছে এটা অস্বীকার করছে না, কিন্তু ওই যে মাঝখানে একটা লোভ দেখাচ্ছে আরেকজন, 11 লাখ টাকা চাও, ক্ষতিপূরণ, ভাড়া। আবার ওই যে একটা দুষ্টুমি করেছিল, সে বলছিল যে আমাকে না দিয়ে আমার অমুকের নামে দিতে হবে। তারা জানতে পেরেছে যে অনেক বেশি টাকা এখন বিক্রি করতেছে ওর কাছে, তো মানে তৃতীয় পক্ষের কাছে দিয়ে দিচ্ছে, তো সেই টাকা আমি নেবো না কেন? এটা হলো তাদের। আমি বললাম যে দেখো, তোমরা তো চুক্তি করে ফেলেছো, টাকা নিয়ে সিংহভাগ টাকা নিয়ে নিয়েছো, 3 লাখ টাকা মাত্র বাকি আছে, আর দখলও দিয়ে দিয়েছো না। তবে এতদিন যে আমাদের, ঠিক আছে, তো এতদিন গড়াইলো 3 লাখ টাকার জন্য ক্ষতিপূরণ কত লাখ টাকা চাও? ক্ষতিপূরণই তো চাও। এই 3 লাখ টাকার জন্য ক্ষতিপূরণ কত হইতে পারে এটা চিন্তা করো। তুমি আরেকজনের কথায় 11 লাখ টাকা চিন্তা করাটা ঠিক না, কারণ ভাড়া তুমি কেন পাবা? আমি কিন্তু এটা মিডিয়েটর ঠিক কাজ করি নাই, এটা মিডিয়েটর আইনের বাইরে কিন্তু, কারণ আমি এখানে ইনভলভ হয়ে যাচ্ছি কিছুটা। বলতেছি যে তোমার 11 লাখ টাকা তো তুমি পাইবা না, কেন পাইবা? যাই হোক, তোরা বলছিস যে হ্যাঁ না, আমরা তারপরে আমরা একটা ক্ষতিপূরণ চাই। বলো কত ক্ষতিপূরণ চাও? তো অনেকক্ষণ চিন্তা ভাবনা করার পরে বললো যে আরো 2 লাখ টাকা দিলে আমরা দিয়ে দিই। তো 3 লাখ আর 2 লাখ এখন এখানেই হয়ে গেল। আদার স্যারকে আবার ফোন দিলাম, কথা বললাম যে ওরা তোমাকে আরো 5 লাখ টাকা, মোট 3 লাখ আর 2 লাখ 5 লাখ টাকা দিলে রেজিস্ট্রি করে দিয়ে দিবে। এরাও এখন রাজি আছে। 11 লাখ টাকা দিতে হচ্ছে না, 2 লাখ টাকা পেয়ে যাচ্ছে। যখন আসবে দেশে তখন রেজিস্ট্রি হয়ে যাবে। প্লিজ ডোন্ট কোট দিস এনিওয়্যার, কারণ এটা কোন মামলার বিষয়বস্তু না, এটা পারিবারিক ব্যাপার, সুতরাং এটা কাউকে কোথাও বলবেন না। কিন্তু দিস ইজ হোয়াট এক্স্যাক্টলি হ্যাপেন্ড। তো যখন কথা বলতে সুযোগটা দেওয়া হয়, আমার এইসব বলার আপনাদের কাছে উদ্দেশ্য হলো এই, যখন কথা বলার সুযোগটা দেওয়া হয় তখন কিন্তু কথা বের হয়ে আসে। কি চাই, কি হলে রাজি হবা, এত চাও কি যুক্তিসঙ্গত? তো আলটিমেটলি আমার জীবনের প্রথম মিডিয়েশন হয়ে গেল। সবাইকে অবশ্যই ধন্যবাদ। আমার সময় শেষ। প্রশ্ন থাকলে অবশ্যই উত্তর দেব।
Thank you, sir, for your resourceful, enlightening, and fabulous presentation. Now it is a time for Q&A session. Ladies and gentlemen, if you have any doubt, query, or confusion, you can ask it to our Honorable Justice Imanali, sir.
সবাই সব কিছু বুঝে গেছে, তার আর কোনো কারণ নেই।
স্যার, আমি একটা ছোট প্রশ্ন করতে চাই।
জি
স্যার, আমাদের কোর্টে দেখা যাচ্ছে যে স্যার ফ্যামিলি ম্যাটার, যৌতুকের মামলা, স্যার মারামারি মামলা, এই মামলাগুলো আমরা সাধারণত স্যার আপোষ করতে পারি, এবং অনেক সময় মেডিয়েটর বিশেষ করে আমাদের জেলা লিগ্যাল কর্মকর্তার নিকট পাঠাই এবং ওখানে আপোষ হয়। কিন্তু স্যার বেশিরভাগ ক্ষেত্রে আমরা সিভিল সুট, বিশেষ করে টাইটেল, যেগুলো রং রেকর্ড অফ রাইট, ভুল রেকর্ডের কারণে যে মামলাগুলো হয়, এবং স্যার ফৌজদারি মানে জাল জালিয়াতির মাধ্যমে যে দলিলগুলো সিজন হয়, এগুলো স্যার আমরা চেষ্টা করেও পারি না। কারণ এখানে একটা পক্ষ স্যার ক্ষতিগ্রস্ত হয় আর একটা পক্ষ উপকৃত হয়, কিন্তু দুই পক্ষ স্যার সমঝোতা আসে না। আমরা স্যার এই বিষয়গুলো কিভাবে স্যার করতে পারি, বিশেষ করে ল্যান্ড রিলেটেড?
এখন ব্যাপার হচ্ছে যে কোনো বিষয়ে আপনি অ্যাজ মিডিয়েটর কাউকে জোর করতে পারবেন না। মিডিয়েশনের বৈশিষ্ট্য হচ্ছে যে আপনি পক্ষদ্বয়কে কথা বলতে দিবেন, তাদের কথা বলতে সহযোগিতা করবেন, তাদের মধ্যে কথা বলতে সহযোগিতা করবেন। আপনি কথা বলবেন না, আপনি আইনের কোনো বিষয় তাদেরকে বুঝাবেন না। দ্যাট ইজ নট ইয়োর ফাংশন। আপনি শুধু তাদের মধ্যে কিভাবে নিষ্পত্তি করা যায় কি না তারাই আলাপ করবে, এবং আপনার দায়িত্ব হচ্ছে এতটুকুন বুঝিয়ে দেওয়া যে আইন বলছে মিডিয়েশনে আসতে, আপনি মিডিয়েশনে এসছেন, ভালো। আইন বলছে আপনারা চলে যেতে পারবেন, যদি ইচ্ছা করেন চলে যেতে পারেন, তবে মিডিয়েশনে যেহেতু আসছেন আমি একটু বুঝিয়ে দিতে পারি যে মিডিয়েশনে থাকলে এই এই বেনিফিট গুলি আছে, যেগুলো একটু আগে বললাম। বেনিফিট গুলা বলে দিবেন, এরপরে যদি তারা চলে যেতে চায় আপনি আটকাইতে পারবেন না, বিকজ ইট ইজ ভলেন্টারি। কিন্তু যদি থাকে তখন আপনি কি করবেন? আপনি কিন্তু তাদেরকে বলবেন না যে তোমার কেস ভালো না, তোমার কেস ভালো, তোমার কেস এত পাইবা, তুমি এত পাইবা না। দ্যাট ইজ নট ইয়োর ফাংশন। Your function is to mediate. In other words, to sit and listen and make them talk. Make them talk. তাদেরকে কথা বলার সুযোগ দিতে হবে, এবং প্রয়োজনে আপনি তাদেরকে কিভাবে কথা বলবে একটা কুছা দিয়ে কথা বলার সুযোগ দেওয়া, এটা হলো আপনার কাজ। না করলে না করবে, কি বেনিফিট গুলো আছে যদি আপনি বুঝাইতে পারেন, আশা করা যায় ইমিডিয়েট সাকসেসফুল হবে মিডিয়েশন।
থ্যাংক ইউ স্যার।
আর কম্প্রোমাইজের কথা বলছেন, কম্পাউন্ডেবল কেসের কথা বলছেন, সেটাও আমরা চিন্তা ভাবনা করছি যে কিভাবে কম্পাউন্ডেবল কেস। আপনারা জানেন, আপনারা জাজ, যে পার্টিরা কিন্তু কোন কেস কম্পাউন্ডেবল কোন কেস কম্পাউন্ডেবল না জানে না, কেউ কখনো বলে না, বিশেষ করে লয়াররা বলতে চায় না, কারণ তারা মনে করে যে মীমাংসা হয়ে গেলে তো আমার কেস চলে গেল। আমি ভাবছি এটা এই সুযোগে আমরা একটা ডাইরেকশন দিতে পারি কিনা, যে যখন চার্জ ফ্রেম করবেন তখন বলে দিবেন যে এই ধারাগুলি আপোষযোগ্য আছে। করবেন না করবেন আপ টু ইউ, আপনার আপোষ করতে হবে সেটা তো আমি বলতে পারবো না। মামলা করলে কি হবে? ও জেলে যাবে, আপনি কি পাবেন? কিছুই পাবেন না। আপোষ করলে কি হবে? কিছু একটা পাইতে পারেন, দ্যাট ইজ আপ টু ইউ টু ডিসাইড। তবে আমাদের সমস্যা আছে। সমস্যা হলো যে আমাদের দেশের প্রেক্ষাপটে যদি আমরা চিন্তা করি, দেখা যায় যে অনেকগুলা ধারা দিয়ে মামলা শুরু হয়ে যায়, এক হাত লম্বা একটা লিস্ট, ইনক্লুডিং সেকশন, মিনিংলেস। ফলে দেখা যাবে যে আপনি যে কম্পাউন্ডেবিলিটির কথা বলবেন, দেখা যাবে যে এর মধ্যে দুইটা একটা সেকশন আছে যেগুলো কম্পাউন্ডেবল নয়। তখন কি করবেন? এটা ডিফিকাল্ট। আমাদের দেশে আমাদের প্রবণতা হচ্ছে যে সব ঢুকাইয়া দাও যাতে বের হতে না পারে। তারপরেও আমি বলবো যে at some stage the public must be told whether or not any particular sections are compoundable, so that they realize that they can compound if they so desire. Yes.
স্যার আসসালামু আলাইকুম স্যার।
জি
স্যার, আমি শিহাবুল ইসলাম স্যার, বিচারক ল্যান্ড সার্ভে ট্রাইব্যুনাল ঝালকাঠিতে কর্মরত আছে স্যার।
জি বলুন
স্যার, আমার একটা প্রশ্ন ছিল স্যার, সেটা হলো স্যার যে ল্যান্ড সার্ভে ট্রাইব্যুনাল তো এটা স্পেশাল ট্রাইব্যুনাল, এটা স্যার স্টেট অ্যাকুইজিশন টেন্যান্সি অ্যাক্টের 145(1) ক্যাপিটাল এ থেকে এই ধারায় প্রতিষ্ঠা হয়েছে স্যার। এটা যে সিপিসির ডিটেইলস প্রভিশন সবকিছু স্যার ল্যান্ড সার্ভে ট্রাইব্যুনালের ক্ষেত্রে অ্যাপ্লিকেবল নয়। সেক্ষেত্রে মেডিয়েশনটা কি ম্যান্ডেটরি কিনা ল্যান্ড সার্ভে ট্রাইব্যুনালে, এটা আবার একটু জানা। যেহেতু 145(d) ক্যাপিটাল ডি, যেটা স্টেট অ্যাকুইজিশন টেন্যান্সি অ্যাক্ট, সেখানে বলা হয়েছে স্যার নিম্নলিখিত ক্ষেত্রে 4টি স্পেসিফিক কথা বলা আছে, যে ইন রেসপেক্ট অফ সামনিং এন্ড অ্যাটেন্ডেন্স অফ উইটনেস, তারপরে রিকোয়ারিং দ্য এভিডেন্স অন এফিডেভিট। এই মোট কয়েকটা ক্ষেত্রে বলা আছে যে সিপিসির বিধান প্রযোজ্য হবে, এর বাইরে ডিটেইল প্রভিশন স্যার প্রযোজ্য নয়। কিছুদিন আগে স্যার একটা জাজমেন্টও দিয়েছে আমাদের জাস্টিস নাইমা হোসেন চৌধুরী ম্যাডামের বেঞ্চ থেকে, সেখানে বলা হয়েছে যে স্যার অর্ডার 1 যে কি বলে মিস কেসও ল্যান্ড সার্ভে ট্রাইব্যুনালে প্রযোজ্য হবে না যদি কোনো মামলা অনুপস্থিতিতে খারিজ হয়, যেহেতু সকল সিপিসির বিধান ল্যান্ড সার্ভে ট্রাইব্যুনালে প্রযোজ্য নয়। সেক্ষেত্রে স্যার যেহেতু 89A, B, C এগুলোর কথা স্পেসিফিক যেহেতু বলা নাই, সেক্ষেত্রে আমরা কি বলতে পারি কিনা যে ল্যান্ড সার্ভে ট্রাইব্যুনালে মেডিয়েশন ম্যান্ডেটরি, এটা কি বলা যায় কিনা স্যার?
আইনটা একটু ভালো করে দেখতে হবে। এই স্পেশাল ল গুলিতে একটু প্রবলেম হয়, যেখানে আপনার কোড অফ সিভিল প্রসিজার অথবা কোড অফ ক্রিমিনাল প্রসিজার অ্যাপ্লিকেবল কি না এটা প্রশ্ন আসে। তো সাধারণত যেটা আমরা দেখে থাকি সেটা হচ্ছে যে সেই স্পেশাল লতেই লেখা থাকে যে এই আইনের যে প্রসিজার আছে, স্পেশাল ল গুলিতে কিন্তু প্রায় দেখা যাবে যে প্রসিজারাল ল ইনকর্পোরেট করা আছে। সুতরাং আইনের মধ্যে যদি প্রসিজারাল ল ইনকর্পোরেট করা থাকে, তাহলে টু দ্যাট এক্সটেন্ট সিপিসি অথবা সিআরপিসি উইল নট বি অ্যাপ্লিকেবল। এবং লেখা থাকে সাধারণত যে এই আইনের মধ্যে যাই থাকুক না কেন, সিপিসি উইল বি অ্যাপ্লিকেবল। তখন সিপিসি পুরাটাই অ্যাপ্লাই হবে। আবার যদি বলা থাকে যে এই আইনের মধ্যে যে প্রসিজার লেখা নাই, সেই ক্ষেত্রে সিপিসি অ্যাপ্লিকেবল অথবা সিআরপিসি অ্যাপ্লিকেবল হবে, তখন আপনাকে দেখতে হবে যে যে প্রসিজারের কথা আপনি ভাবছেন সেটা সেই আইনের মধ্যে আছে নাকি নাই। যদি সেই আইনের মধ্যে না থাকে, then you can fall back on the CPC or CRPC. So it all depends on how the wording of the law is. বিভিন্ন আইনে কিন্তু বিভিন্নভাবে লেখা আছে। সুতরাং যদি বলা থাকে যে এই আইনের বিধান থাকা সত্ত্বেও যেখানে প্রসিজারাল ল এই আইনের মধ্যে যেটা নাই সেটা সিপিসি থেকে আনবে বা সিআরপিসি থেকে আনবে, যদি ওইভাবে লেখা থাকে তাহলে your 89A, B, C will be applicable. আর যদি দেখা যায় যে মিডিয়েশনের কোনো বিষয়বস্তু আপনার স্পেশাল লর মধ্যে আছে অলরেডি, তখন 89A will be ousted, কারণ the special law already provides for that procedure. আমি কি বুঝাইতে পারলাম? সেই স্পেশাল লতে যদি থাকে, then general law will not apply. স্পেশাল লতে যদি না থাকে এবং স্পেশাল লতে যদি বলা থাকে যে যেই প্রভিশন গুলো এখানে নাই, সেসব প্রভিশন সিপিসি থেকে আনতে পারবেন বা সিআরপিসি অ্যাপ্লিকেবল হবে, তখন আপনার জেনারেল ল থেকে প্রয়োগ করবেন।
স্যার আসসালামু আলাইকুম। স্যার আমি মোহাম্মদ রফিকুল ইসলাম, জেলা আদালত বরিশাল।
জি
স্যার, বিজ্ঞ কৌশলীদেরকে উদ্বুদ্ধকরণের একটা স্যার প্রোগ্রাম আপনারা যদি একটু নিতে পারেন স্যার, কারণ ওনারাই মূল স্যার। তো আপনিই বলেছেন স্যার, একটু আমাদের সমস্যা যেখানে ওখানেই হয়, যে মামলাটা চলে যাবে আর আইনের সঠিক পরামর্শ স্যার সবসময় দেয়া হয় না। মামলা যে খারিজ হয় আমরা দেখেছি যে শুধু স্যার ওই সকল কারণেই। আর স্যার এনআই অ্যাক্টের মামলার ক্ষেত্রে যেহেতু ওই ধারাটা স্যার হলো স্যার কম্পাউন্ডেবল না, আপরযোগ্য না, বাট বেইলেবল, এখানে স্যার এইটা একটু সমস্যা। যদি উল্টে যেত স্যার, যদি এটা আনবেলেবল হতো এবং আপরযোগ্য হতো, এখন স্যার আমরা 29 বিএলটি দিয়ে আপিলে আমরা নরমালি স্যার এগুলো আপোষ করলে পরে সেখানে জবানবন্দি নিয়ে হলো স্যার আমরা ওইভাবে রায় দিই 29 বিএলটিতে যে কেস লটা আছে ওই ভিত্তিতে স্যার। এখানে স্যার একটু আপনারা যদি কর্তৃপক্ষকে আপনারা ওইভাবে একটু সাজেস্ট করতে পারেন কিনা স্যার?
আমি আপনার শেষের প্রসঙ্গটা আগেই বলি, সেটা হচ্ছে যে আমরাও আপিল বিভাগে এসে আপনারা দেখবে যদি একটা রায় আমাদেরই আছে, আমারও হয়তো একটা রায় বা দুটা রায় আছে, যেখানে আমরা বলেছি অলরেডি রিপোর্টেড কেস, যেখানে আমরা বলেছি যে হ্যাঁ এটা নট কম্পাউন্ডেবল, দ্যাট ইজ ফ্যাক্ট। সুতরাং কম্পাউন্ডেবল বা কম্প্রোমাইজে আমরা যাব না, বাট নেভারদারলেস যে টাকা পেয়ে গেছে, সাজা খেটে ফেলেছে কিছু অংশ, সুতরাং পিরিয়ড আন্ডারগোন করে আমরা ছেড়ে দিচ্ছি। এক্স্যাক্টলি আমরা কম্প্রোমাইজটা বা কম্পাউন্ডেবিলিটিটা আমরা নলেজে নিচ্ছি না, কগনাইজেন্সে নিচ্ছি না, বাট নেভারদারলেস ডিসপোজ করে দিচ্ছি, বিকজ উদ্দেশ্যটা কি আইনের? টাকাটা পাওয়া, টাকা পেয়ে গেছে এবং ইতিমধ্যে সে কিছু সাজাও কেটেছে, আর কিছু চাই না, এখানে নিষ্পত্তি করে দিচ্ছি। আর আপনি যে অ্যাডভোকেট সাহেবদেরকে উদ্বুদ্ধ করার কথা বলেছেন, এটা গোস্বামী বাবু শুনতেছেন, আমরা এটাও সাজেস্ট করেছি এবং আমরা এটা বলতে পারি যে আপনারা যখন ওই যে আমি যে বললাম একটা ডেট যদি রাখেন মিডিয়েশনে পাঠাবার জন্য, এবং ওই ডেটে যদি উকিল সাহেবের সামনে কথাগুলি বলেন, তাহলে আমার মনে হয় উকিল সাহেবও কিছুটা উদ্বুদ্ধ হবে। আর আরেকটা কথা, আমরা যেটা আমি আপিল বিভাগে কিন্তু অনেক কেস মিডিয়েশনের জন্য পাঠাই, এবং তখন আমরা বলি লয়ারদেরকে যে দেখেন, উই নিড ইয়োর হেল্প, আপনারা আমাদেরকে সাহায্য করেন, ইউ আর অফিসার্স অফ দ্য কোর্ট, এভাবে বলি, ইউ আর অফিসার্স অফ দ্য কোর্ট, উই নিড ইউ টু হেল্প। যেমন গত সপ্তাহে একটা কেস আমরা পাঠিয়েছি, 2 ভাইয়ের মধ্যে মামলা, এক ভাই আরেক ভাইয়ের চেহারা দেখবে না জীবনে। Whereas এটা এমন একটা কেস যেখানে মিডিয়েশন করা যায়, তারা একটা এগ্রিমেন্টের মধ্যে আসতে পারে। সো আমরা বলেছি 2 লয়ারকে যে দেখেন, ইউ আর বোথ অফিসার্স অফ দ্য কোর্ট, উই এক্সপেক্ট ইউ either to mediate yourself or get them to compromise the issues. পাঠিয়ে দিয়েছি, কি হবে জানি না, but that is how to engage the lawyer. Give the responsibility to the lawyer. লয়ারকে বলেন যে duty to help the court. তখন কিন্তু আর পিছপা হইতে পারবে না। আর যে জিনিসটা তারা বেশি ওয়ারিড, সেটা হচ্ছে তাদের দুধাল গাড়িটা চলে যাচ্ছে। এখানে যেটা তাদেরকে বোঝানো দরকার, এবং এটা আমার মনে হয় again it is matter of awareness building, যে গায়ে একটা চলে যাচ্ছে, আরো তো 10টা আসবে। আপনি যদি দেখাইতে পারেন যে আপনি এগুলো খুব ভালো করে করতে পারতেছেন, আপনার অল্প সময়ের মধ্যে টাকা পেয়ে যাচ্ছেন, ফি পেয়ে যাচ্ছেন, আর আরো 10টা মামলা আসলে সেই 10টা ফি পাবেন। whereas একটা মামলা করতে লাগবে আপনার 6 বছর, আর এখানে আপনি 10টা মামলা করতে পারবেন 10 দিন লাগবে, না 1 মাস না লাগলো। এগুলো যদি তাদের অ্যাপ্রিসিয়েশনের মধ্যে আনা যায়, then only we can succeed.
স্যার, আমি জেলা জজ পিরোজপুর থেকে বলছি স্যার। স্যার, আপনার বক্তৃতার শুরুতে আজকে একটা ড্রাফট সার্কুলারের কথা বলছিলেন। স্যার, আমার একটা নির্দিষ্ট সুপারিশ, যে গতদিন আমাদের একজন পার্টিসিপেন্ট তুফাইল বলেন যে আমাদের অনেক ভারী কেসের লোড নিয়ে মিডিয়েশনের জন্য সময় দেওয়ার মতো সময় থাকে না। এর উত্তরটা আপনি স্যার ভালোভাবে দিয়েছেন। আমার স্যার একটা সুনির্দিষ্ট প্রস্তাব, যে কিছুদিন আগে সুপ্রিম কোর্ট থেকে একটা সার্কুলার হয়েছে যে আমাদের সিআর মিস গুলো শোনার জন্য একটা সার্কুলার দিয়ে বলা হলো যে বিকালে আপনারা শুনবেন। আমরা বিকালে এটা যখন ফিক্সড করছি, অ্যাডভোকেট সাহেবরা থাকছেন, সিআর মিস তাদের কাছে খুবই গুরুত্বপূর্ণ, এবং ওনাদের উপস্থিতি থাকলে অন্য অন্য কেসগুলো ইচ্ছায় অনিচ্ছায় তাদের মক্কেল তাদেরকে অন্য অন্য কোর্টে নিয়ে যায় সকালের দিকটায়। আমার নির্দিষ্ট প্রস্তাব হচ্ছে এই এডিআর এর জন্য আমাদের যদি বিকালটা একটা নির্দিষ্ট সময় প্রত্যেক কোর্টের জন্য নির্দিষ্ট করে একটা সার্কুলার জারি করা হয়, তাহলে আমার মনে হয় একটু ফলপ্রসূ হবে। ধন্যবাদ স্যার।
থ্যাংক ইউ, দ্যাটস এ ভেরি গুড সাজেশন। এবং আমি বলবো যে আমি আপনাকে বলবো আর আপনি করবেন, এটা কেমন কথা? ইউ আর দি জাজ প্রিসাইডিং ইউর কোর্ট, ইউ উইল ডিসাইড যে আমি বিকালবেলা শুনবো ওগুলি, এবং মেকিং শিওর ইউ রিমেম্বার and the lawyers remember that through mediation you can dispose of 10 cases in a month, whereas একটা মামলা করতে গেলে লাগে 6 বছর, 10 বছর, আরো বেশি লাগে অনেক সময়। মিডিয়েশনে যদি আপনি তাড়াতাড়ি নিষ্পত্তি করতে পারেন, এটা আপনি জানেন, সবাই জানে যে এটা ইজিয়ার এন্ড কুইকার। সো আপনার ফেস ঠিক করেন, বিকালবেলা আপনি যেটা বলছেন ইটস এ ভেরি গুড সাজেশন। আপনি যদি
যেমন স্যার সিআর মিস আমরা তো আগেও করতাম, একটা সার্কুলার পাওয়াতে কিন্তু অ্যাডভোকেট সাহেবরা এখন বাধ্য হচ্ছেন যে হ্যাঁ সুপ্রিম কোর্টের সার্কুলার, জজ সাহেবের কিছু করার নেই। আমরা স্যার এরকম একটা সার্কুলার পেলে আমাদের একটু বাধ্যবাধকতা আসে, আইনজীবীদের উপস্থিতিটাও বাধ্যবাধকতার মধ্যে আসে, এই জন্য আমার বলা স্যার।
ঠিক আছে, ঠিক আছে, আমি আমার তো আর সেই ক্ষমতা হয়তো নাই, আমি চেষ্টা করব যাতে এরকম একটা সার্কুলার ইস্যু করা যায় কিনা আমরা ভেবে দেখি। থ্যাংক ইউ ফর
this is Nahid Nasrin.
Sir,
Joint Justice Judge Perezpur. I would like to ask a question, sir.
Yes.
In a civil suit, if the defendant is government, GP always represents the government. But in most of the cases, plaintiff is interested to resolve the case or dispute through mediation. But the defendant represented by the government is reluctant to resolve the dispute. So in this situation, how a mediator, the presiding officer, disposes such cases through mediation?
Well, simply said, government is also a party to the litigation.
Government is not anything very special and high mighty. In a suit, the government is just another party. Again, it goes back to the saying that if they do not agree to mediate, then you cannot force them. But to send to mediate is your duty, you're bound under the law. Government agree করুক আর নাই করুক, যেতে হবে। সুতরাং যেদিন আপনি বলবেন লয়ারদেরকে, গভর্নমেন্টেরও তো একজন লয়ার থাকবে, পক্ষেরও একজন লয়ার থাকবে, দুই পক্ষকে ডেকে, দুই লয়ারকে ডেকে বসিয়ে বলবেন যে there is this section called 89A of the CPC. I am bound to adjourn the case and send it for mediation. You like it or not? তারপরে বলতে হবে যে these are the benefits of mediation, early disposal, etc., etc. If you like, you can go through with it. If you don't like, you can come back. But that is the process. You must send it for mediation. Before you send it for mediation, you must tell them exactly the benefits, attractions of mediation. But you cannot force anyone to mediate. That is the problem with mediation. But there is also, I think, the mediation that does not detract from the benefits of mediation.
Assalamu alaikum, sir. Myself,
Bhola bolte jacchen apni ekটু থামেন দেখি, শ্রীজাজ ভোলা বলতে যাচ্ছেন।
স্যার, আমি ডিস্ট্রিক্ট জাজ ভোলা মাহমুদুল হক স্যার। আমি এই মেডিয়েশন সম্পর্কে আমার কিছু অবজারভেশন আছে এই এডিআর প্রসেস সম্পর্কে, আমি সেটা একটু বলতে যাচ্ছি।
জি,
ফার্স্ট অফ অল স্যার আমি একটু বলতে চাচ্ছি যে আমি স্যার এই মেডিয়েশনের উপরে রিসার্চ করেছি, ইনডেপথ রিসার্চ, এবং আমি পিএইচডি ডিগ্রি লাভ করেছি এবং আমি এর উপরে একটা বইও লিখেছি এডিআর এর উপরে। তো আমি এই যে কন্টিনিউয়াস রিসার্চে আমি কিছু জিনিস দেখেছি, সেটা হলো যে বেশিরভাগ ক্ষেত্রে আমাদের পারিবারিক মামলা এবং নারী শিশুর 11 গয়ের মামলাগুলো অনেক আপোষ হয়ে যাচ্ছে, কিন্তু সিভিল মামলাগুলো আপোষ করার ক্ষেত্রে অনেক সমস্যা হচ্ছে আর কি। তো বিশেষ করে এই সিভিল মামলাগুলো আমরা মেডিয়েটর প্যানেলের অ্যাডভোকেটদের যাদেরকে দিচ্ছি, দেখা যাচ্ছে যে তারা অ্যাডভোকেটরা এই পার্টিদের নিয়ে তাদের সময়ের কারণে বা অন্য কোনো কারণে বসছেই না, একবারও বসছে না। এবং আমি যতগুলো মামলা রেফার করেছি তাদের 90%-এরও বেশি মামলা তারা ফেরত দিচ্ছে, তারা একবারও বসছে না। আর এই সিভিল মামলাগুলো নিয়ে আমাদের বিচারকরাও বসছে না, এবং বসলে অনেক প্রবলেম হচ্ছে যে সিভিল মামলা নিয়ে যখনই বিচারকরা বসছে তখন দেখা যাচ্ছে যে পার্টিরা বিচারকদের আর বিচারক মনে করতেছে না, তারা ওই মেডিয়েটর মনে করছে, এবং এই বিচারকদের ডিগনিটিটা সেটা ওই পার্টিরা ঠিক মতো ওই অনার ওইখান থেকে একটু সরে আসছে। তো এজন্য কিন্তু সিভিল পারিবারিক মামলা এজলাসেই অনেক মামলা আপোষ হয়ে যাচ্ছে কিংবা বসলে আপোষ হয়ে যাচ্ছে, কিন্তু আমাদের যৌতুক নিরোধ আইনের 3 ধারা বা 4 ধারা এখানে কিন্তু আমাদের আপোষের বিধান নাই। আবার নারী শিশু আইনের 11 গ ধারা ওখানে আপোষের বিধান নাই, কিন্তু প্রচুর মামলা এই মামলাগুলো আপোষ হয়ে যাচ্ছে। আবার আমরা ডিস্ট্রিক্ট লিগ্যাল এইড অফিসারকে আমরা আপোষের জন্য কিছু মামলা পাঠাচ্ছি, সেখানে একটা সমস্যা হচ্ছে যে ডিস্ট্রিক্ট লিগ্যাল এইড অফিসার অনেক পারিবারিক মামলা আপোষ করছে, কিন্তু তাদের অন্যান্য কাজেরও কারণে তাদেরও কিছু বার্ডেন থাকছে। এখানে আমার একটা প্রপোজাল, যদি আমরা ফার্স্ট অফ অল একটা কাজ করতে পারি যে কোনো আর সব জাজ কিংবা সব অ্যাডভোকেট মেডিয়েটর হিসাবে ভালো মানে কাজ ভালো করতে পারে না। কিছু কিছু জাজের মেডিয়েশনের পাওয়ারটা অনেক ভালো, সে অনেক ভালোভাবে মেডিয়েশন করতে পারে এবং অনেক মামলা নিষ্পত্তি করতে পারে। আবার কিছু কিছু জাজ এটা একেবারেই কম পারে। এই জন্য আমরা প্রত্যেকটা জেলাতে যদি কোনো জাজকে, যেমন যেটা আছে লোক আদালত, সেরকম কোন একজন জাজকে আর অ্যাডভোকেট একজন সাথে দিয়ে একজন কিংবা একজন জাজকে ইন্ডিভিজুয়ালি একটা উইকেন্ডে যদি আমরা করতে পারি, অ্যাসাইন করতে পারি, উনি যে যে মামলাগুলো আপোষের যোগ্য সেই মামলাগুলি উনি ওই দিন সারাদিন আপোষের জন্য কাজ করবো। ওনার সাথে একজন অ্যাডভোকেট প্যানেলে থাকলো, একজন সোশ্যাল ওয়ার্কার থাকলো, ইন্ডিয়াতে যেমন আছে সেরকম লোক আদালতের সিস্টেমে যদি আমরা প্রত্যেকটা জেলাতে করে যদি একটা কম্প্রোমাইজ কোর্ট যদি আমরা করতে পারি এবং প্রত্যেক উইকেন্ড শুক্র শনিবারে তারা বসলো এবং আপোষগুলোতে একটা আপোষের পরিবেশ সৃষ্টি হবে এবং তাতে দেখা যাবে যে অনেক আমরা সিভিল মামলাও সেখানে তখন অ্যাডভোকেটরাও এটাতে গুরুত্ব পাবে, পার্টিরাও এটা গুরুত্বের সাথে এটা নিতে পারবে এবং ওই মামলাগুলো দেখা যাবে যে অনেকগুলো নিষ্পত্তি হতে পারবে। আর আরেকটা জিনিস সবচেয়ে যেটা ফ্রুটফুল হয় সেটা যদি আমরা একটা জয়েন্ট ডিস্ট্রিক্ট জাজ অথবা এডিশনাল ডিস্ট্রিক্ট জাজ লেভেলে একটা পার্মানেন্ট একজন মেডিয়েটরকে নিয়োগ করতে পারি, যে সে একজন জাজ হবে এবং সেই জাজের স্পেশাল ট্রেনিং থাকবে মেডিয়েশনের উপরে এবং সে ফুল টাইম একজন মেডিয়েটর হবে এবং প্রত্যেকটা কোর্ট থেকে আমরা ডিজনার নারী শিশু মামলার 11 গ যৌতুক নিরোধ আইনের এবং অনেক মামলা যেগুলি সহজে আপোষযোগ্য, যেগুলো আইনে আপোষযোগ্য, সেই মামলাগুলো তার কাছে দিলে সে সপ্তাহে সব দিনই সে যদি এইটা ট্রাই করে এবং তাকে আমরা যদি মেডিয়েশনের উপরে ভালো ট্রেনিং দিতে পারি, তাহলে দেখা যাবে যে একজন জাজের চেয়ে 5 থেকে 10 মামলা নিষ্পত্তি করতে পারবে এই মেডিয়েশনের মাধ্যমে। তো এরকম একটা পদ ক্রিয়েট করলে সবচেয়ে ভালো হয় এবং যে পর্যন্ত পদ ক্রিয়েট না হবে তখন আমরা সপ্তাহে একদিন কাউকে অ্যাসাইন করে দিলে, কারণ সিটিং জাজদের মেডিয়েশন করা অনেক সময় ডিফিকাল্ট এবং দেখা যাচ্ছে যে পার্টিরা তাতে অন্যরকম ভাবে অধিকার প্রয়োগের চেষ্টা করতে পারে। এজন্য মেডিয়েশনটা একটু আলাদা করে এবং এই সাথে আমরা যদি কিছু ট্রেন্ড মেডিয়েটর প্রত্যেকটা জাজশিপের অ্যাডভোকেটদের ট্রেন দিতে পারি এবং তারাও এদের সাথে কাজ করতে পারে, তাইলে এটা দেখা যাবে যে এটা অনেক বেশি ফ্রুটফুল হবে। আমাদের আইনে মেডিয়েটর প্যানেল বলা আছে, সাধারণত মেডিয়েটর প্যানেল অ্যাডভোকেটরা সিনিয়র অ্যাডভোকেটদের দেয়, তারা আগ্রহ করে মেডিয়েটর প্যানেলে নাম দেয় কিন্তু ইনফ্যাক্ট তারা মেডিয়েশনে বসেই না। সুতরাং যারা ইয়াং এনার্জেটিক জুনিয়র কিংবা সেমি সিনিয়র অ্যাডভোকেট তারা একেবারে ফুল প্রফেশন হিসাবে এই মেডিয়েশনটাকে নিবে, এরকম কিছু অ্যাডভোকেট যদি আমরা সৃষ্টি করতে পারি তাহলে আমার মনে হয় এই পুরো প্রসেসটাই অনেক ফ্রুটফুল হবে। কারণ আমাদের সিভিল মামলাগুলা বিশেষ করে আমরা যদি টার্গেট করি তাহলে দেখা যাবে যে 25 থেকে 30%, ইভেন 50% সিভিল মামলা আমরা এই মেডিয়েশনের মাধ্যমে সাকসেসফুলি নিষ্পত্তি করতে সক্ষম হব। থ্যাংক ইউ স্যার।
ধন্যবাদ আপনাকে, অনেক লম্বা একটা আপনি বক্তৃতা দিলেন, ভেরি গুড, উই অ্যাপ্রিশিয়েট ইট। আমার প্রথম সাজেশন হবে যে সিন্স ইউ আর সো নলেজেবল and we respect your knowledge, you please write an article and distribute it to all of us. That will benefit, I think, everyone. Number one. Number two, আপনি বলছেন যে appoint a judge as mediator. That is not possible under the law. Because আইনের মধ্যে স্পষ্ট লেখা আছে যে রিপাবলিকের বেতন প্রাপ্ত কেউ সেই মিডিয়েটর হইতে পারবে না। একজন জাজ, ফুল টাইম জাজ cannot be a mediator. I cannot be a mediator. You cannot be mediator unless you yourself are mediator in your court. Then you can be mediator. A person receiving office of benefit, office of profit under the republic cannot be a mediator. So I think a judge cannot be, a particular judge cannot be appointed as a mediator to mediate all cases. A particular, each and every judge can be a mediator in his own court. And legal aid officer can be mediator in his own office. But you cannot appoint, for example, Mr. Mohiduzzaman as a mediator to mediate all cases. That cannot be done. Weekend mediation, I agree with you, that is a very good idea. If only the judge will agree, that means a judge from the mediator panel. You as a judge sitting in your court, you can mediate, but you can only work during court hours. You cannot work beyond court hours. So you cannot do the mediation of your cases during the weekend. কারণ আপনার সময়সীমা কোথায় আছে যেন আমি দেখেছি যে between 9:30 and 4:30, এর বাইরে আপনি কাজ করতে পারবেন না, অফিসিয়াল কাজ করতে পারবেন না। 4:30 পর্যন্ত আপনি কাজ করবেন এবং 4:30 আগে যে মামলাটা আপনি ধরবেন সেটা আপনি যতক্ষণ ইচ্ছা কন্টিনিউ করতে পারেন, কিন্তু এর বাইরে কোনো কেস, নতুন কেস আপনি নিতে পারবেন না। So you cannot work as a mediator of your court's cases during the weekend. But mediator from the panel can do the mediation at any time. ওখানে কোনো restriction নাই। যদি
লয়ার আর পার্টিরা যদি এগ্রি করে, well and good, we can take on. I don't see any problem. And most of all, again I repeat, I think your knowledge should be distributed and disseminated to all of us. একটা article লেখেন, benefits and disbenefits of mediation, problems arising in mediation, so that we can all get the benefit of your knowledge.
স্যার আমি হাসানুল ইসলাম বরগুনার জেলা জজ স্যার কিছু বলতে চাচ্ছিলাম স্যার আমি ওই ভোলার জেলা জজের সাথে জাস্ট একটু অ্যাড করব স্যার আমি আমার বরগুনার জেলার লিগ্যাল এইড অফিসার এখানে আছে আমি আজকে এখান থেকে নির্দেশ দিচ্ছি আমার বরগুনা জেলা লিগ্যাল এইড অফিসারকে যে আমার যে লিগ্যাল এইড অফিসটা আছে সেটা কালকে থেকে আর রবিবার থেকে মেডিয়েশন সেন্টার হবে আইনত যেহেতু লিগ্যাল এইড অফিসার লিগ্যাল এইড অফিসার মেডিয়েশন করতে পারে আমার ওই অফিসটাকে লিগ্যাল এইড সেন্টার মেডিয়েশন সেন্টার করব যে আইনজীবী এবং যে লিগ্যাল আইন বিচার প্রার্থী যারা আছে তারা যেন উদ্বুদ্ধ হয় তো একই সাথে আমি বলবো স্যার ওই যে আমাদের ভোলার জেলা জজ যেটা বললো একজন বিচারক নিয়োগের বিষয়ে সেটা যদি সিনিয়র অ্যাসিস্ট্যান্ট জাজ না হয়ে যদি যুগ্ম জেলা জজ পর্যায়ে কাউকে লিগ্যাল এইড অফিসার নিয়োগ করা হয় তাহলে বোধ হয় এই ওর যে প্রস্তাবটা আরো কার্যকরী করা যায় মনে হয় কারণ যুগ্ম জেলা জজের সকল ধরনের মামলা নিষ্পত্তি করার সুযোগ থাকে একজন সিনিয়র অ্যাসিস্ট্যান্ট জাজের একটা পিকুনিয়ারি জুডিশন থাকে যুগ্ম জেলা জজের সেটা অনেক বেশি পরিমাণ থাকে এবং সব ধরনের মামলা সে নিষ্পত্তি করতে পারে স্যার আপনার দৃষ্টি আকর্ষণ করছে এই বিষয়ে
থ্যাংক ইউ একটা ডিফেক্ট আপনার কথার মধ্যে সেটা হলো যে ওই পেকিনারি জুরিসডিকশন আমি কিন্তু এর আগেও বলেছি মিডিয়েটরের কোনো পেকিনারি জুরিসডিকশন নাই হ্যাঁ আপনি বলতে পারেন যে যুগ্ম জেলা জজ হলে তার এক্সপিরিয়েন্স বেশি থাকবে দ্যাট ইজ ট্রু সো হি মে বি এ বেটার পারসন অ্যাজ এ মিডিয়েটর I may be the best person as a mediator being the oldest among all of you but that does not necessarily mean that I have to be appointed a mediator and that a junior assistant judge cannot be appointed a mediator because mediation does not require judicial functioning, does not require judicial knowledge. It simply requires the quality as a person to sit in between two disputing parties. আর আপনি যেটা বলছেন ভেরি গুড সাজেশন যে আপনি লিগ্যাল এইড অফিসে যদি পারেন মিডিয়েশন সেন্টার করতে ওয়েল এন্ড গুড লাস্ট টাইম আমরা ট্রেনিং এর সময় একটা সাজেশন এসেছিল সেটা হলো যে চিফ জুডিশিয়াল ম্যাজিস্ট্রেট বলেছিলেন যে নতুন বিল্ডিং যেখানে হচ্ছে সেইখানে আমরা 3টা বা 4টা রুম মিডিয়েশন সেন্টার করে করতে পারি দ্যাট উড বি দি বেস্ট আইডিয়া আই বিলিভ কারণ আপনার সেই ক্ষেত্রে এই আপনার মিডিয়েশনের এসেনশিয়ালি মিনিমাম 3টা রুম দরকার ওই যে আজকে আপনারা আরো শুনবেন হয়তো কালকে শুনেছেন যে 2টা রুম দুই পক্ষের জন্য যদি আলাদা করে রাখতে হয় ফোকাস যদি আলাদা করে স্পেসিফিকলি কারোর সাথে কথা বলতে হয় তখন 2টা রুম প্রয়োজন হয় একটা ওয়েটিং রুম লাগবে যারা বসবে এক সাইডে সো 3টা রুম মিনিমাম দরকার আপনার মিডিয়েশন সেন্টারের জন্য 4টা রুম হলে আরো ভালো হয় একটু ওয়াশরুম ফেসিলিটি থাকতে হবে আশেপাশে এগুলো আপনারা চিন্তা করে যদি মনে করেন চিফ জুডিশিয়াল ম্যাজিস্ট্রেট সাহেবরা যারা আছেন যাদের নতুন নতুন বিল্ডিং অট্টালিকা হচ্ছে ওনারা যদি ওখানে হাউস করতে পারেন মিডিয়েশন সেন্টার দ্যাট উড বি দি বেস্ট সলিউশন আর আপনি যেটা বলছেন যে লিগ্যাল এইড অফিসারের এখানে হ্যাঁ লিগ্যাল এইড অফিসার তো এমনিতেই তার অফিসে মিডিয়েট করতেই হবে বাট আদারওয়াইজ যদি আপনি মনে করেন যে ওইখানেও স্পেস আছে রুম আছে মিডিয়েশন সেন্টার করার জন্য ওয়েল এন্ড গুড করতে পারেন আচ্ছা এখানে বন্যা খাতুন বোধহয় বন্যা খাতুন কথা বলতে চাচ্ছিলেন বারবার ডিসি জাজ সাহেবরা ওনাকে ইন্টারাপ্ট করছেন আমি একটু ওনাকে শুনি
আসসালামু আলাইকুম স্যার
ওয়ালাইকুম সালাম জি বলেন
Sir, I have a question. Sir, basically we know that parties' willingness is the most important factor to resolve a dispute in case of mediation process, and appearance also the important factor to gain the precious result. So my question is that, sir, in case of civil suit, especially partition suit, where the defendants and parties number in more, like 100 and another times the hundreds and more, then how a successful resolving of this suit is possible by incorporating the mediation process?
That's a very good question. So if the parties are numerous, what do you do?
Yes, sir.
I think even then, if the parties are agreeable, 100 জনের আপনি 100 জন জায়গা করবেন কোথায় মাঠে তা তো পারবেন না এখন কোর্টে কিভাবে করেন
কোর্টে তো সবাই একসাথে আসে না,
Yes,
কোর্টে
sir.
একজন প্রতিনিধি করে 10 জনের জায়গায় একজন পাঠিয়ে দেয়।
Yes.
সুতরাং আলাপ করতে পারেন, ট্রাই ইট।
Yes.
পার্টিরা তো আপনার সামনেই থাকবে, পার্টিদের লয়ার আপনার সামনে থাকবে।
Yes.
Mediation, again, even in a partition suit, mediation is a must
Yes, sir.
under the law. সুতরাং ওই সময় আপনারা ডিসাইড করেন যে কিভাবে করলে সবার জন্য সুবিধা হয়।
Yes, sir. Sir, I have another question. You most of the times, sir, you say personal capability of a judge becoming a mediator. This capability depends on the quality to manage the public.
Yes,
His
in
personal
fact, that is more important than knowing the law. The important factor in mediation is psychology,
Yes, sir.
not law, because
Yes.
you have to know the mind of the parties. You have to know how to control the parties. You have to know how to control, if you like, warring parties. Because when parties come to a litigation, they are at war. Everyone, both sides want to win.
Yes, sir.
And both sides want the other side to lose.
Yes.
So you are the one, the mediator is the one who controls them, controls their emotion. And the mediator must know about emotions and how to control people's emotions. You know, it's all very well saying, be quiet. But you can't say be quiet. You can say, please, take your turn. উনি কথা বলছেন, আপনি ওনাকে শুনেন, তারপরে আপনার কথা বলেন. So controlling and managing is more important than knowing the law. Knowing the law is good. Knowing the law is necessary, of course, because for your own good. But otherwise, it is the parties who are doing the talking. It is the parties who are doing the decision making. And you are not even to advise. কালকে যেটা বলা হয়েছে যে আইন এটা বলছে আপনার পক্ষে আছে, আইন ওটা বলছে এটা ওনার পক্ষে আছে, এগুলো আপনার বলার দায়িত্ব না, বলবেন না, আপনি বলতে পারেন না।
Thank you for such a beautiful Q&A session. Right at this moment, I am humbly requesting Honorable Justice Kurian Joseph, former Judge of Supreme Court of India, to describe the role of judiciary in encouraging mediation.
Thank you. Thank you. And in that, esteemed Brother Justice Imam Ali, and dear sisters and brothers from the judicial fraternity. Let me also ask a question to Justice Imam Ali, because I've been listening to him. Sir, what is that restriction that a judicial officer cannot do this mediation beyond the court hours? Because left to me, in my experience as a court in the High Court, my mediation sessions in the chambers continued even up to 8 o'clock, 9 o'clock. My brother judge also used to sit with me in the other chamber. So we will not leave the parties unless we get some sort of a solution. In the sense, we used to keep them, because once they go back, we know for sure that they will get into the hands of those lawyers and they will not encourage mediation. They will not encourage a settlement. So that is one thing. Secondly, we used to keep them under our surveillance and give to them follow-up also. I don't know if there is some sort of a restriction that you are right, a judicial officer cannot do a private mediation because you are otherwise in the holding an office of profit. But you are actually doing a legal service, and being a court, because you are a judge 24/7, not 9:30 to 4:30. So is it not your judicial, is it not part of your judicial work to continue? Suppose a matrimonial dispute comes in the chamber of a district judge and before the court of a district judge, and then he himself involves in the mediation, and then it's a conciliatory mediation. Goes into conciliation, both parties speak separately and then jointly. If children are also there, then they are also, their assistance also is sought to bring the parties together or in amicable settlement, etc. So will it not take time beyond the court hours also?
The question, I think, is not that the judge cannot work beyond court hours, but the court cannot function beyond court hours, because the judge who is mediating in his court is an officer of that court, and he is continuing his work as a judge of that court. Now, I don't know if it may be the same in India, but here the court hours are restricted, and the judge is, rightly or wrongly, restricted to working or taking cases between 9:30 and 4:30. And the law says
that he can continue a case which he has taken up before 4:30, but he cannot take up a new case after 4:30. So
we have no such restriction. We take up new cases also after 4:30, 5:30, 6:30, even Delhi High Court also.
Yes, but that we're talking about the law judiciary, and that is what the law actually specifically says. For
trial, you're right. Trial may not. Beyond court hours, you cannot go for trial. Yeah.
So, and mediation is again yet the same case, but in a different format. So I suppose the way out is to take it up at 4:29 and then continue until 10 o'clock at night. That's fine.
It's a good clarification. Yeah, or you can just you can call the case in the morning, send the parties to have the assistance, and then call them to your chambers and resume that mediation continue also. Now I get a good clarification because the restriction or rather prohibition is for the judge to take up another mediation which is not within his court and to do the private mediation. No, that is that is of course prohibited. But there is no harm after all, as I understood, that in a judge continuing the mediation beyond the court hours in respect of a case in which he had already started mediation in the court on the particular day.
Absolutely.
That's great. Yeah, it's a good clarification. That's perfect. That's good.
And I'm sorry I've taken up your time.
No worries at all. It was wonderful because, sir, actually, though you answered many of the questions in Bangla, sometimes you answer. I mean, the questions were in Bangla and you answered in English, so I could catch the real doubts also. These are actually this is the best way to conduct this session also, because all of us have listened to so many lectures, but what is actually in the ground is something which we need to, particularly the last question. One of the last questions, when numerous parties are. So there are practical issues or practical problems we face, when there are other matters also, when there are criminal issues also involved. So there are so many issues which we need to address on a practical ground, which they themselves may not be in a position to take a decision. But getting a backup from the Court of Appeal or from the High Court is something great for them. Yeah. That's great, sir. That's wonderful. So in fact, you have done my session also, so my job is far easy. My dear sisters and brothers in the fraternity of judiciary, my only task is just to take forward as to your great passionate mentor, Justice Imam Ali, put to you. In the last session when I had the different set of judges, I said, we become judges because we have a passion to do justice. That is the core object of becoming a judge, according to me. It's not the position. Yes, it's a position. It's not the jurisdiction. Yes, it's a jurisdiction. It's not a power. It's a power. It's a question of status. It's a status. But it's not simply that. Beyond that, we have a definite mission. That mission is to do justice. Justice between the parties who are litigating before us. So they may not litigate on a question of law. As Brother Imam Ali said, in a partition case, what is the question of law in a partition case? Ultimately, if you peel the onion, ultimately, there's nothing left on the last peeling. Likewise, many of the civil disputes or quasi-criminal cases also, which they come before us as judges. When we start actually tracing back the history, I always say the epicenter, the mediator's greatest role is to see the epicenter. When there is an earthquake, the greatest, the first thing that people do, where is that epicenter, the starting point? So the mediator should be in a position to know where exactly these people started this misunderstanding or lack of understanding or wrong understanding. These are the three things: misunderstanding, lack of understanding, wrong understanding. These things started. If you are able to take them back to their old memories, just to have a little bit of a postmortem going back, not to add more pain to the wounds, but to trace them back as to where exactly the dispute started. And if you are able to rebuild from that only, if you inspect, rather, if an engineer inspects a dilapidated building, if he wants to refurbish it or reinforce it, then he will chip it and chip it and chip it to the point where the crack started. From there, he'll have to grout it and then bring it to a strong building as it originally is. Likewise, the mediator has a great role in actually analyzing. That's why probably your section 89 also starts with the phraseology where it appears to a judicial officer that there exists an element of settlement. So it should appear to you. How does it appear to you? Unless you have a passion to do justice, it will not appear to you. Our conventional role as an adjudicator judge is almost the exclusivity of that adjudicator role is gone. Now the judge is in your legal aid, you're an educator. Now the judge is a mediator. Now the judge is a conciliator. Now the judge is a negotiator. Now the judge is a peacemaker. Now the judge is a judicial officer adjudicating and rendering judgments. So our conventional role is, my role is only to hear the case and render a decision. No, that's gone now. That concept is gone. You have ever so many roles now as a judge. This is how the role of judiciary comes in. If we have a passion to do justice, then we will have 100 ways to do that justice. Ultimately, when we go to sleep, we will have to ask a question to ourselves: for how many people have I been able to render justice so that they were able to touch justice and get the relief? Get the relief. What is that relief? Relief is not winning the case. Relief is actually a peacemaking process. What peace have I contributed in my role as a judge in my court today? Because, lack of peace is one reason. The result of a litigation is lack of peace between the parties, in the community, in the society. So restoring that peace, peacemaker, restoring that. So what peace have I contributed, have I made in my court today is one of the questions probably you can ask. So, my dear friends, I just wanted to tell you our orthodox or conventional role of an adjudicator judge is gone now. We have so many other roles also, and some of them, as I said, you are a peacemaker, you are a mediator, you are a conciliator, you are an educator, you are a negotiator. I'll speak something about a bit of a negotiation also in the process, because let me go step by step. So, my dear friends, you have to handle 4 people according to me in court. If you want to have a successful role as a mediation-friendly court, to become a mediation-friendly court, first of all, you will have to handle the lawyers. Because without their cooperation, we will not be able to have successful conduct of any mediation, not only in the court, successful in what you call successful implementation of this mediation among the parties also. Then you will have to handle the litigants. Yes, how do you handle the litigants? If you are able to convince the lawyers first that that your duty, you owe a duty. Your lawyer also owes 4 duties, no? A duty to the client, duty to the court, duty to the society, and duty to the court, opposite side. Yes, on the 4 duties, you must remind the lawyers that they must cooperate in bringing in peace between the parties, which will have a cascading effect of bringing peace in society also. So therefore, if you're able to convince, they are always concerned because, if all cases are settled, what are we going to do? This question that lawyers always ask. Sir, you are actually not permitting us to make our roti chawal. Some lawyers used to say on the trials that I have heard. No, it's wrong. See, you must then, the second step is to educate the litigants that, a lawyer who cooperates for settlement of a case in court or outside court should be paid the same amount of fee or more fee. So in the court, if you should be in a position to convince the lawyers that, your professional returns are assured and then you don't lose anything by settling a case. Don't think that you are getting your fee only for arguing the case. Yes, assisting the court by arguing the case is one thing, but assisting the court to bring about peace between the parties is equally important and equally a wonderful role a lawyer can play. So the most concerning worry of the lawyer is about their rewards, their fee, their returns. So convince the parties that only because the case was settled that you don't have to pay the fee. No, you will have to pay. So the more number of cases the lawyers assist to get settled, then the litigants will have more faith in those lawyers that here is a well-meaning lawyer who will help me not to argue the case and shout in the court, but to find out some relief to me. Ultimately, what I want is actually not defeating the other side, but actually getting a relief to me. This is the mindset change you have to make on the litigants. It's not a person has come to the court not to defeat the other side, but to get relief to the one who has come. Sometimes these people entertain a wrong notion that even if I lose, let them lose. This is actually sometimes the notion, the vendetta, the feeling that you should be in a position to melt in court. This is the great role of a peacemaker judge, a conciliator judge, a mediator judge, an educator judge, because these are all your different roles, not simply the adjudicator. And then I'll come to the negotiation a little later. So you have to handle the lawyers, the litigants, and the third factor which I have identified from my practical experience is the court clerks, lawyers clerks. What do you call it? Munshi. I don't know in what language. The one who assists the lawyer in coming to the court and preparing the brief, and this Gumastan we call it, Munshi we call it, lawyers clerk we call it, advocate clerk we call it. I don't know what language you use in Bangladesh, but they are the people who are more in contact with the clients than the lawyers, than anybody else. So many ordinary people will always, be going by their advice only. The lawyers class, the munshis. So you should in fact have an education for them also. 3. The 4th is the court staff. The staff in your court should have faith in this process of mediation, because sometimes these litigants get in touch with the staff also. If the staff says, no, this judge is simply for wasting the time, he says, nothing going on. You ask your lawyer to argue the case. That one word will spoil the whole thing. Then the party will lose everything, all faith in the mediation. So please educate your lawyers. Please educate your litigants. Please educate your munshi, the munshis of the lawyers. Please educate your own staff in the court. This is very small. I'm saying only small tips. If they are able to have this conceptual idea, if they're able to conceive the fruits of a good mediation, a peacemaking court, a settling court, then things will change radically in the country, in the town, or in the village, or in the district where you are. This district will be famous in the country of Bangladesh, because there is a judicial district where people get peace, not get judgments. People, not simply reliefs, people get peace. Think of a relief which the people ultimately are not getting peace. You can give any relief, but all reliefs will not give peace to them. They will get peace only if the right relief is granted. And right relief is actually the reconciliation between the parties, and ushering in peace between the parties, and settling the disputes between the parties also. That's number 1. Number 2, you have a great role. You see, of the parties who have come to your court, there may be only one case before you, but there may be related cases also. So please ask the parties, are there other related disputes also? They will tell you there are many other disputes also. I'm sure the CPC in your country also permits that. A judge can always go for a compromise in respect of cases which are not in court also. Other cases also you can settle. That's the provision in India. I'm sure the ditto provision is there also. So ask about other, because by settling one case, it's not going to end, because they will pick up quarrel in other cases also. So when you settle a case or a dispute through mediation, have an integrated approach, a wholesome approach. Integrated approach means, settle all disputes between them, mediate all differences between them, mediate all disputes between them, so that, tomorrow they are not going to continue this acrimony. Tomorrow they are going to, tomorrow onwards they are going to have a new face in society that people have come to terms, and they have settled all their disputes. Will you believe, I have a case when I inquired, I got 64 cases between the same parties, which finally I settled in the Supreme Court. When I was a judge in the Supreme Court, I had a case of 64. My record in the High Court was only 42. I settled the disputes between the parties. In one case which came before me, then I had this habit of asking them what are other disputes in the 42. But when it came to Supreme Court, I found between the parties there existed 64 cases. I settled all of them, which had a criminal flavor, civil flavor, corporate flavor, all cases, commercial flavor. Is all cases are settled, and they are living so happily. The families are living so happily. There is peace in society also, and the police is happy because half of their time they were spending to take care of the warring groups in that society. So a good judge, which should be in a position to look into the integrated mediation of the whole disputes between the parties also. And then coming to the negotiation part. Suppose, as Brother Imam Ali said, having appeared before you that there is an element of settlement, and then you draw the terms of settlement and refer the parties to an appropriate alternate dispute settlement of either arbitration or a mediation or a conciliation or a settlement, judicial settlement through permanent law adalat, whatever it is. Then, suppose the parties go and have their court-referred mediation. They go and they are not able to settle. They come back mediation. As you know, the mediator cannot report anything on the merits. They can only report the mediation failed. Don't leave the parties there. Please call the parties and then ask them in the court. You please ask, where was the acute, or what was the parting point, or where was the point where you were not able to agree? What is the distance between them? And there comes the role of a negotiator as a judge. Because you are in the open court, you are not doing a private mediation, you are not doing a private session there. You are in the open court because mediation has already taken place, and it is reported that it has failed or partly failed. Then in the presence of the lawyers and in the presence of the parties, they have come. Then you have a right to ask, and they have a liberty to ask, why has it failed, and what is actually the point of difference. I have had several such experiences in court, both in the High Court and in Supreme Court, where parties reported failure. Then, lawyers, mediator reported failure. Then I called the lawyers and asked them what is the problem. The lawyers said, this went only this much, this went only this much, it didn't progress. Then once again, I called the parties in the presence of the lawyers, because after having educated the lawyers, I have won the confidence of the lawyers to proceed. So the lawyers also will assist me at certain stage. Sir, if you can do a little bit of persuasion, not pressure, but a persuasion. Little bit of a persuasion from a judge makes a whole lot of difference. So what is that persuasion? This persuasion is in legal terms called a negotiation. So now we are going to negotiate the relief between the parties, right? They have reached at some stage in the process of mediation, but they are not able to. So distance is 10 feet. Distance is 10 feet. In figurative terms, I'm saying difference is 10 feet. So when the parties are before you, why don't you ask? Why don't you walk 5? Why don't you ask 5? So both sides are persuaded to walk little, not 10 feet. Because before the mediator, the position is in letting walk 10 feet. The other side says, no, I don't walk even 1 foot. Then in the court, as a negotiator, you can just persuade them, why don't you walk 5 feet? Why don't you walk 5 feet? Then you're able to meet. I have several such situations or examples of the court-involved negotiating role where the parties agreed, All right, sir. Since the court has said so, because now we will educate them that it is for your benefit. Otherwise, you are losing, the other side is winning. Then the next court, and the people, even if there is no remedy left, this hurt feeling, this feeling of having lost will always remain as as a burnt, what they call indigested food. This indigestion will always remain in the party who lost it. At some stage, it will again crop up in a different shape. Don't think that the litigation is ending up to the Supreme Court. One litigation, if it ends in Supreme Court, the party who lost will again start another round of litigation, not on the same issue, but in some others, because he doesn't want to suffer that ignominy or humiliation of having lost before that man. Whereas if both parties go, as both of them have won, nobody has lost. It's a win-win situation. Probably Anindita is looking at me and smiling. Is it my time? I don't know. The other speaker is waiting. Yeah, I will wind up in 5 minutes. Yeah, if both parties are able to go from your court as having won, your prestige is not, your self-respect is not, you have a peace in your mind, your families are at peace, you have saved money, you have saved time, you have saved energy also. This is actually the great role of a judge as a negotiator, because in negotiating a relief and something that comes from a judge makes a whole difference, because in that negotiation, you will also be partly using this role of an evaluative mediator. I'm sure all these roles should have been sent, because Batna, Waltna, Mlatna, all this have been explained to you, I'm sure. Because you can, as a judge, always say the best alternative, the worst alternative, and the way they call that most likely alternative also. So on this, you will be in a position to have an evaluative role as a judge. When the judge makes an observation, because judge gives an observation as an evaluator, then it will go a long way in finding a solution to the problems. So an evaluator and negotiator is the role of a judge in court, even in a situation before, even a situation where the mediation has failed. So first of all, you are an educator, you are a conciliator, you are a mediator, you are a negotiator, you are a peacemaker, you are an adjudicator. And then, you have to educate the lawyers, the litigants, the lawyers, munshis, and your court staff. And then, in the court, you have to take up these roles of a negotiator and an evaluator. If you do these things, then you will be in a position, because all other aspects, I'm sure I saw the topics also. You might have been told also the benefits of mediation, etc., etc. But I told you some practical points also. And regarding the numerous parties, just to add to what Brother Imam Ali said, even numerous parties are there. That's the best thing. That's the best ground for a good mediator, because we have something called a community mediation. Because numerous parties not belonging to the same community is very good. It's a court-referred mediation, private mediation, community mediation. These are the three types of mediation. A lot of community disputes can be settled by a good judge, because a lot of scheme suits come before you. Lot of suits under section 92. I don't know if the same section there also. I'm sure it's the same section 92 CPC. Scheme suits come before you because there's a dispute in the community, in the group, in the society, in the trust. This is the best role the judge can play, because you will have to tell them what is the intended purpose of this trust, intended purpose of this society, intended purpose of this association. Then you have to take up and educate them. You'll be able to do wonderful jobs. When coming to the numerous parties, though parties are numerous, but dispute will be the same. Number one. Number two, underlying interest will be the same. Number two. Number one. Number two, if the underlying interest is the same, countless maybe or numerous maybe the hundreds maybe the parties, but their interest is the same, then you should be in a position to catch hold of that interest and build on a solution on that. Thank you, my sisters and brothers. I may have to wind up for constraints of time, because there is another session also on this, and you have to take your lunch also thereafter. If you have any question, probably if I'm not able to answer also, Brother Imam Ali is still there. You can ask, or you can leave this question answer session also and leave to the next speaker also.
Thank you, sir, for your comprehensive discussion on the role of judiciary in encouraging mediation. Ladies and gentlemen, this is the Q&A session. If you have any doubt or query, Honorable Justice Kurian Joseph Sir is here to answer.
My only handicap is I'll be able to answer only in English, neither Hindi nor Bangla.
Okay, sir.
It's your 1 o'clock there now, if I'm not wrong.
Sir, it's 1, 2.
Okay. Yeah, it's almost your next session, yes.
Yes.
Assalamu alaikum, sir. This is Bona Khatun. I have a question, sir.
Yes.
Sir, becoming a presiding judge on my own jurisdictional base court, if I want to become a mediator, if the suit is fixed for step under section 89A of CPC, then during the court hour, allowing the parties sometimes, personally, 30 minutes or 1 hour for assisting the mediation process. Actually, can I have a chance for this for assisting this process?
Yeah, Bona, see, if you read your section 89A also, see, actually, your role is not to first of all take upon yourself the mediation. You have to refer it to mediation. That is your first role, because you have to form an opinion that this is a case that is good enough or fit enough, or that's an appropriate case for one of the alternate modes of settlement. And what is that appropriate mode of settlement? That you have to form an opinion. And then probably your first role comes to refer it to mediation. And in that mediation, once having referred, you can make a follow-up, there is no problem. And even if it fails also, you can get back the parties and then take upon yourself. Instead of first of all involving yourself first, I would advise you as a prudent method that, first of all, please refer to a competent mediator. And in case the mediation succeeds, very well and good, because while referring a case, please prepare the parties before you refer the parties to mediation. Please prepare them as to what are they going to do and what they should do and how much cooperation the lawyer should give and what's their attitude. And that preparation will go a long way in actually settling, in finding a compromise in a mediation. And in case that mediation fails, probably at that stage, I think it will be more prudent, more appropriate to have the judge's own involvement as a mediator, as a second stage.
Sir, I want to say personal consideration of this case. Basically, it's not valid the judicial ethics.
Personal
consideration. I think my first question is regarding that the personal consideration on this case. Somehow my duty also be questioned, like I valid the judicial ethics.
Yeah, your judicial ethics does not prohibit you from playing the role of a mediator.
Yes, sir.
No, it actually it's 100% ethical, it's 100% permissible, it's 100% mandated that that you prepare the grounds, prepare the parties for an appropriate mediation, send them for mediation, and then in case it succeeds, very good. Even if it fails, then you can yourself involve in that process of mediation and see, as I told you, as a bit of a conciliator or a negotiator or an evaluator. All these three roles you can play at that stage. But it's really prudent always to refer them first to a mediator, because you can do your other works also.
Yes, sir. Thank you.
Add here, if I'm permitted. Anindita, can I interrupt for a moment, please?
Yes, sir.
Justice Imam Ali wanted to add something.
Yes, if I can just refresh what section 89A1 actually says, just the relevant parts. After filing of written statement,
the court shall mediate in order to settle the dispute or disputes. So the first priority is for the court itself to take up the mediation or refer the dispute or disputes to concerned legal aid officer or to other mediators from the panel of mediators. So the first thing is the court itself can judge itself as the mediator if the parties choose. Now here again, we must emphasize that the parties will choose whom they want to be mediator. The mandate is on the court to adjourn the case for mediation. First thing. Second, the court will then give the parties the opportunity to say, yes, we will agree for you to mediate, the judge of that court. Or we want the legal aid officer to mediate. Or we want somebody from the legal aid panel to mediate. So the choice is with the party to decide who will mediate. And at that stage, the court will accede to the request of the party, to a decision of the party. But adjourning the case and mediating is the first priority.
Yeah, wonderful. Yeah, see, the reason is, you know the process of mediation. It is voluntary and it is party-centered. So a proper education given to the parties in court, probably they will say, let us first take the chance of a mediation from a qualified mediator outside, because the court is busy. Court has other works also. So when the party says, you should be very happy, because if you are going yourself to mediate, then your other works also will suffer. So from my experience, I would say, educate the parties in such a way that, they first chooses a forum which a qualified the mediator to go and have a mediation, so that your other works do not suffer. Or you can have a legal aid. Yes, legal aid mediation. So that's wonderful. Yeah. It is party's choice. It is party-centered and it is absolutely voluntary.
Thank you, sir, for this beautiful question and answer session.
Sir, I'm District Judge Bhola. I have some question that in your country, India, the permanent and continuous Lok Adalat and also in Lok Adalat, there have some huge success mediating and conciliating the matters, but the scope there is very limited and success rate is not so very good. Have you any plan to expand this alternative dispute resolution and mediation process in courts widely? And in some cases, we find that some matters, there involve some matters that is not compoundable under law. If just like of matter is if comes, how you handle this matter in that case? Thank you, sir.
Thank you, Madam Hawk. The way I understood the question is, as far as there are 2-3 aspects. One, permanent Lok Adalat and continuing Lok Adalat. Lok Adalat is different from mediation, first of all. And in Lok Adalat, actually the parties also sit with an Adalat, sit with a competent person who is in a position to decide. Whereas in mediation, there is no decision. Mediation is only settlement. In Lok Adalat, you pass an award, which has the force of a decree, with the consent of the parties. Making them agree, you persuade them, you get into the situation sector, you have lot more involvement in Lok Adalat. Whereas in mediation, your role is facilitator, then your role is evaluator, and bit of a negotiator. But the 90% of your role is only facilitator. As Brother Imam Ali was saying, permit asking the parties to speak, parties to communicate, parties to evolve solutions, parties to find alternatives, parties to come to terms. So you are only actually helping them, assisting them. It's called an assistant mediation. You're only just assisting them. Whereas in Lok Adalat, your role is different. If you have sat on a Lok Adalat and you call the parties, ask them what is the problem, why don't you do it, all right. What do you owe? This much. See, this party owes 200. All right, why don't you say 100? Make it 100. All right, 100. Finish. This is no longer the. Whereas in mediation, you can't do that role also. That is the first part of it. Second part of your question is actually non-compoundable offenses. Non-compoundable offenses, you need to seek the assistance of the High Court, because only under that 561 those can be quashed. Because if you send a report to the High Court, probably, or if you refer to the parties to the High Court with this note that they have settled, and therefore it is in the interest of justice and to secure the ends of justice that the criminal cases are quashed. Non-compoundable cases, the court and the trial court cannot do anything. Only the High Court can quash it to secure the ends of justice. I'm sure the High Court will do that exercise. So it needs a second level of what they call a friendly litigation in the High Court.
Thank you, sir. Thank you for your reply. In this time, I would like to invite Mr. Kevin Berry Brown, PhD, Course Director of Bangladesh International Mediation Society, Ombudsperson of United Nations and Green Climate Fund IMI, Qualified Assessment Program IMI Certified Mediation Training Program, President of Mediation International, to describe the role of mediators.
Thank you. Thank you very much. I'm just going to put on, share my screen if I may. Okay, well, so again, thank you. It's wonderful to be here today. Great to see everybody here and present. There's I'd like to thank the BIMS for organizing this again. I think they do just an amazing job putting this together. And I'm trying to get there we go. Also, honored guests, judges, lawyers, mediators, other speakers, friends, thank you all for being here today and for being available to listen to me speak and share with you about the role of the mediator. Now, my job today to talk about the role of the mediator, I was present yesterday when my colleague Tanushree spoke, and she touched on the process. She spoke to the mediation stages. She spoke a little about the role of the mediator. I'm going to expand on that a little bit, and for example, Tanushree, she mentioned yesterday 5 steps or 5 stages to mediation. Depending upon who you speak with, there are different number of stages and on how they're put together, and it really doesn't matter if it's 4, 5, 6, 7, or 8 stages, as long as all of the stages are included. Some people divide each stage up into separate parts, and other people just simply put them all together. And what's really important is that all of the different roles of the mediator are covered in the different areas. Now, as was mentioned, my name is Kevin Brown. I'm here to talk to you about the role of the mediator. I have well over 30 years of experience as a mediator, as an ombudsman. I've been an ombuds with the United Nations, with the Green Climate Fund, and I'm currently doing mediation as well with the European Space Agency. Now, each of those different areas have different ways of operating. And you, as judges, mediators, will come to terms with your own way of running things, of organizing things. And as I mentioned, what's most important is understanding your role as a mediator. Earlier today, it was mentioned that it doesn't matter as much about how much of the law that you know, but what's most important is psychology. I completely agree. That's exactly what mediation is all about, is understanding the people, knowing the people, not personally knowing the people, but knowing how they're responding, how they're reacting, and finding ways of getting them to listen to each other. Probably the greatest role of a mediator is to listen. And I find that a huge part of that listening component is to get the other people to listen as well. Now, when I am doing mediations, I have a few stages that I go through. The first stage is pre-mediation. And this is what I use that you see in front of you. As I mentioned, there's other ways of doing it, but this is the way I operate. And in the pre-mediation stage, I find I do the vast majority of my work, whether it's a family mediation or community or civil and commercial or workplace or an international mediation. The bulk of the work of a mediator's work is done in the pre-mediation stage when they have that opportunity to speak with the lawyers, to speak with the clerks, to speak with the litigants, to speak with the parties, and to find out what's really going on and what their underlying needs are. Also, it's the opportunity for you to get the litigants or the parties to the point where they're able to listen to the other person. As was earlier mentioned, everybody wants to talk. Everybody believes when they come to you, believes or go to court that they are right and that they will win. Their lawyers have told them that they are in the right and that they will win, and they will walk away with a lot of money. And they're prepared to talk and say what's going on. Rarely do they come prepared to listen to what the other person has to say. And in reality, this might be the very first time when they come to mediation that they're actually able to spend some time listening to what the other person has to say. Now, when I get to the initial joint session with the people, that's probably the most important area for you as a mediator. Your job and your role there is to let people know what's going on. Oftentimes, a mediator will say to me that, I'm doing mediation this afternoon and it's filled with lawyers, so I really don't put much into my opening statement. I kind of gloss over the opening statement so that people can, just get down to the important stuff and start to talk. And I completely disagree with this. I think it's an absurd way of operating mediation. I believe you as a mediator, it's your job, your role to spend a lot of time on your opening statement, because this is when you're building trust with the parties. And if the parties don't trust in you, they're not going to talk. They're not going to listen to the other person. They're going to let their lawyer do all of the talking for them. So in my initial joint session, I will spend a lot of time talking to people, telling them what's going on, what they can expect, what my role is as a mediator, and what their roles are, and what their lawyers' roles are. My preferences is always for the parties to do the bulk of their talking. I much prefer to hear somebody say, on this day, this is what occurred to me, rather than on this day, my client, etc. It's much better to have the parties speaking. And in the pre-mediation stage, I make that very clear to the people and to the lawyers so that they are prepared to let the parties speak. Don't forget, the two parties are going to be sitting there. They had this problem a year ago, whenever it was, and they probably have not spoken to each other since. So this is an opportunity for them to have a conversation with not have a conversation, but to share with the other party what their needs, what their interests, how this has impacted them. Now, the initial joint session, when the parties speak, they are not interrupted. It's a monologue for them. They get to speak and continue speaking until they finish speaking. I might interject, and I often will. I will use my skills as a mediator. I will paraphrase, I will summarize, and I do this so that the person knows that they're being heard, and I'm doing it so that the other person hears what the person is saying. Oftentimes, I will tell people that, your job is to listen while the other person is speaking, but that doesn't always happen. Oftentimes, you can imagine what they're doing. While one person is speaking, the other person is writing down notes about what they're going to say. They are thinking about what they're going to be saying in the next few minutes, and they miss a lot of what is said. by the other party. So I jump in there and I get very involved, and I summarize and I paraphrase. I ask questions. I do ask probing questions in order to find out what's really going on from the party. Once that's happened, I then have to make a decision. I make a decision if they're going to have another joint session. And that decision is based on how the people have been behaving in the meeting. The vast majority of my cases, I do go on to the second joint session. And because I believe, and I believe this was also said earlier today, that the parties are, if they are willing and able to speak with each other in a respectful way, that's what mediation is all about. If there's going to be a lawyer there that is grandstanding, thumping his chest, saying what's going to happen in court, I'm not going to waste everybody's time with that. I will then I will then separate the parties and go into caucus. But if they are behaving and are being respectful to each other, well, then I will let it continue, and I will let the questions come. I will let both parties ask questions of the other party. The caucuses themselves, oftentimes the private caucuses, they provide opportunities for me or you as a mediator to find out more information, to ask questions that might not be as appropriate to ask during an actual session when the other party is there. It's also an opportunity for people to release some of their emotions. You will find, at least I have found, that the vast majority of cases have an emotional element to them. And that emotion might end up being tears. It could be anger. It could be yelling, banging on the table. These are all of these emotions are oftentimes best dealt with in a private caucus. When you see people becoming emotional or becoming irate, it's a good opportunity to go into a caucus. Often after the caucus, I will bring the people back together. I much prefer as a mediator to not do shuttle mediation. Shuttle mediation is when one group is in one room, the other group is in another room, and I go back and forth between the rooms. That is not the type of mediation that I like to operate under, but it's a requirement because the people just aren't ready. And that brings us to the closure. I have three types of settlements: either fully resolved, partially resolved, or not resolved. Oftentimes, the partial or the not resolved can become fully resolved through follow-up. I'm not sure how it works in Bangladesh, but I would hope that you as a mediator will have the opportunity to follow up with the parties, because oftentimes you're able to help get things resolved once people have had a little bit more time to reflect on what their options are, especially if the next stage is going to court. So the role of the mediator is right there in front of you. You don't take sides. You're not a judge here. You're a mediator. You're helping them to come to their own conclusions. You create opportunities for them to listen, to hear the other person, and you provide professional, neutral, independent assistance to them. Your role here is to facilitate the conversation, to help them to reach some sort of a satisfactory outcome. Now, what makes a mediator successful? There's all sorts of people out there that are operating as a mediator, some much more successful than others. A lot of research has been done on this, and the research attributes that the mediator's success globally and domestically, they relate to three specific factors. The mediator, first of all, allows the parties to deal with issues that they themselves feel are important. It's not up to you as a judge, as a mediator, to decide what's important and what's not important. That's up to the parties, because whatever's important to them is what they need to resolve. Oftentimes you'll hear things that you didn't think were going to be all that important, but they're important to them, so let them discuss them. The mediator allows the parties to present their views fully, doesn't interrupt them, doesn't allow the other person to interrupt them, giving the people the opportunity to fully express their views and let them know that they are being heard. Now, how do you do that? You do that through your own body language. You do that through nodding. You do that through asking questions. You're asking probing questions, paraphrasing, summarizing, all of those skills that I'm sure you're learning today and yesterday and in any mediation training. Now, the parties who have enjoyed successful mediations find that their favorable attitudes towards mediation, they stem from a few different elements as well. The greater a degree in participation that they have in the mediation leaves them with a greater satisfaction in the mediation process itself. The more opportunities to express themselves and communicate their views are important. There's significant studies that have been done over the years because mediation throughout the globe has been around for many years now. When I grew up started mediating in Canada, that was 30 years ago, and it was quite popular back then, or became quite popular back then. Many countries today, Spain being one of them where I'm currently living, haven't really grasped hold of mediation. So it's evolving. It's evolving in some areas. In my 30 years of experience, every conflict has had some element of emotion wrapped up into it. Lawyers and most other professionals involved in conflict management believe that disputes oftentimes are managed through the use of rational decision-making and objective reasoning. However, when a group of experienced mediators were asked, I think it was a group of 2,000 mediators, they were asked what they wished they had been taught more of during their initial mediation training. Their answers were how we would like to have known more at the beginning, how better to respond to the negative emotions that people bring to the mediation with them. Emotions such as fear, anger, shame, pain, grief. They were looking for methods to increase their emotional intelligence, ways of becoming more aware of and responding to the energies of conflict. Methods for opening up heart-to-heart conversations between the parties and knowing how to strike the right balance between the head and the heart. Kenneth Cole, he's an author out of the United States, I believe. He wrote a book called Building Bridges Between Psychology and Conflict Resolutions. And it's a wonderful book, a wonderful text. It's in English, and it really gives a lot of insights into what mediators over the years have said that they would like to have more of. So, recognize that experienced mediators found it nearly impossible to separate the emotional drivers behind the conflict and with the facts. Conflicts can only be resolved if the underlying emotions are identified and are addressed. This requires mediators to be emotionally literate and possess a degree of what is described as emotional intelligence. An emotionally intelligent mediator must develop basically 4 skills: the ability to identify one's own emotions and that of the others, the ability to harness emotions and apply them to tasks such as thinking and problem solving, the ability to manage emotions, including the ability to regulate their own emotions, and the ability to affect the emotions of the others in a negotiation. As was said earlier, you can't just tell them, okay, shut up. You have to stop talking right now. That's not really going to get you very far. There are other ways of saying the exact same thing. And that is what a good mediator or an experienced mediator has learned. Europe, like Italy, Greece, I wish I could say Spain, but they're not there yet. Turkey is doing it. And there's places in America and Australia where they continue to have, and Bangladesh, where they continue to have voluntary mediation, but there is a mandatory component to it. The mandatory component is attending an information session. At the end of that information session, the parties decide yes to mediation or no. If you look around the globe, and I will use Italy as a prime example because they really are they were the first group, or the first country that started doing this. Italy is now doing over 200,000 mediations a year with their courts. And that's because people have voluntarily chosen to go into mediation. They were mandated to go into a mediation session, and they learned about mediation. They learned about the benefits, and they decided to move ahead. And Greece is another perfect example. In 2015, believe it or not, they did 7 mediations in the entire country. 7. They're doing now over 300,000 a year. So this mediation session, it takes an hour out of their time. They pay, I think it's about 40 euros in order to sit in on it. But that 40 euros is very well spent because they decide that they want to go for a mediation as opposed to going to the courts. So some of the other areas that have also been talked about, neutral, that your job there is not to judge, not to make decisions for the other parties, not to say who's right, not to say who's wrong. You're independent. If there are any circumstances that may or may not be seen to affect your independence, you either shouldn't be doing the mediation, or you have to announce that or disclose that this is something that's there that may cause either the conflict of interest or the perception that there's conflict of interest. Confidentiality, I don't think we need to speak to that. And even in organizations, which in different areas, they have different types of mediation. My role within the United Nations, or with the Green Climate Fund, or with the European Space Agency, they all have different ways of doing things and how those proceed. So there's no one cookie cutter way of doing a mediation. Different mediations in different areas are done differently, but the reality of the situation is they're all so very similar. So 3 areas I wanted to talk about here are the procedure, the fairness of the process, and the end of the process. The mediator's role is to ensure that the parties to the mediation understand the characteristics of the mediation process and the role of the mediator, their role, and the role of their lawyers. In the vast majority of the cases I do that are going to court, the parties are there with their lawyers, and they each have very distinct roles. The mediator's role is to ensure that prior to the commencement of the mediation, the parties have understood and expressly agreed to the terms and conditions. I use an agreement to mediate, very straightforward, written up by a lawyer years ago, and it's a standard mediation agreement. And of course, I use that in each and every case. It talks about the conduct and the proceedings and the respect and what each person's role is throughout the actual mediation. The fairness of the process, it's your role to ensure that all the parties have adequate opportunity to be involved in the process. That's, the most important part. One person should not dominate the process. You control the process, and you have to make sure that the parties are given equal opportunity. Now, the end of the process, hopefully it will be with full satisfaction on both parts, but that isn't always possible. So you have to set up appropriate measures to ensure that any agreement that has been reached has informed consent, and that all parties understand the terms of the agreement. It's fortunate that you'll have, in most cases, lawyers present, so that becomes their role to ensure that their clients that fully understand what they're agreeing to. I ask the parties at the very beginning, for process reasons, that I tell them it is voluntary, and I tell them that they can leave at any time. But I also get them to commit to not just walking out the door. Oftentimes people become upset. They hear things that they don't want to hear. So I get them to commit to give me 5 minutes alone with them and their lawyers before leaving. And that I have found has made a huge difference in bringing people back together. Let me talk about a little further about the stages of the mediation. I'm going to go quickly because I've spoken mostly about this already. And the pre-mediation, as I said, that is the area that I spend the most time in. The bulk of my time is spent there getting the clients and the lawyers prepared to go into the mediation. If it's a particularly complex mediation, you have to be very careful to make sure that you fully understand these substantive issues. Read in advance any of the important materials, the pleadings, the court rulings, orders, legal authority, contracts, depositions, hearing transcripts, anything that is part of it, you need to read ahead of time, simply because you're not going to have the time during the mediation itself. Ask for them, make sure that the party representatives are there. That should be there. Always find out ahead of the mediation who is going to be present, who they're bringing with them. And if they're not bringing everybody that they want to bring, make sure that they have the ability to contact those persons during it. The worst thing that you want is to be in the middle of a mediation, getting very close to resolving things, and only to be told that they can't make a decision because so-and-so is not present and they can't reach them on the phone. Horrible situation to be in. This is my mediation room. You obviously have the choice to set up your room however you want to. It's also very different today because the vast majority, all of my mediations today are done online. I haven't been in a room with more than 4 people in over a year. So it's, this is all because of COVID. But when I was doing mediations in a room with the parties present, this is the layout that I would have. I'd have the 2 parties beside me, their lawyers beside them, anybody else or witnesses or any experts that they wanted to bring with them down there. Not always did I need to have all of those people there. But when they do that's basically the setup that I would have. I already spoke about the opening joint session, how important my opening statement is. I talk about the mediator's role. I talk about what I'm able to do, what they're able to do, what their role is. I spend a lot of time on my opening statement because, as I said, that's the point where you're trying to build trust with the other parties. You're building a relationship with the parties, making them be more comfortable sharing information with you. If they don't trust you, if they don't believe in you, if they don't think you're going to be able to help them, they're going to clam up. They're not going to say anything. They're just going to sit there or let their lawyer do the talking. I also talked to them about a little further about my role. I talked to them about how I may need to interrupt them speaking, how I control the process, not the people, how that I will ask them to wait and to listen. I will paraphrase. I will make sure that the other party is listening and is understanding. Oftentimes I've had people apologize in a mediation and the other person was too busy with what they were about to say, thinking about that they completely missed the apology. And so I would pull them back to that. And apologies go a long way, a very long way. They don't resolve everything, but they do help move things dramatically forward. Understand body language. That's really, really important. That's part of the psychology of doing a mediation. Watch for and look for nonverbal cues. Read their language, read the way they're sitting, what they're doing. Always be flipping back and forth. When one person is talking, your role is to also make sure that the other person feels and believes that they're still there. They're still part of it. Don't just focus on one person and ignore the other person for 10 minutes, because then that person you start to lose them. You want to make sure that you're watching them, you're seeing their body language, and you're able to understand what they're saying. And if you don't, it's easy enough, you ask them. They then get to make their opening statements. I let people know ahead of time what I expect from their opening statement, some of the facts, what they would like to achieve in today's mediation. And my job essentially is to listen. This was mentioned earlier. Our learned judges mentioned this earlier. Listen, listen, listen. It is such an important and straightforward and seemingly obvious thing that we have to do. But you will hear things when you're really, really listening, active listening, taking notes. You're also making that decision if you're going to have another a joint session. Whatever, probably the most important thing, other than listening, is taking the notes. Oftentimes, mediations will carry on. I can be doing 4 or 5 mediations at a time, at any given time, over the periods of a few weeks. And you really want to make sure you're not getting them confused. Taking notes really can make a big difference, so that when you get back together with them in a week's time, let's say, you're fully prepared again to get into whatever where the topic was left off. During the joint discussion, this is either the easiest or the hardest area for the mediator. The easiest time is when people are well prepared. In the pre-mediation, you have given them a lot of help in preparing. Their lawyers have been involved and have been talking to them to do, how to do it, and being respectful within a mediation. Or it can be the hardest stage, when the lawyers start yelling and screaming and, as I said, thumping their chest, we're going to win, we're going to take this all the way. And when you get those situations, that's usually when I just abruptly end and go into caucus, because all that does is set up a case to go to court, and it's really a waste of people's time if that's all that's happening in a mediation. I've spoken about everything that's there. The caucuses are also very important, as I mentioned earlier. This is when you can get a lot of information. You can talk to them about a strategy. You can talk to them about their watnas or their batnas. These were mentioned earlier, and they were mentioned yesterday. And you can talk about moving forward. This can be done in 1 session or 2 sessions or 5 sessions, depending upon how you as an individual want to operate your mediation. In those caucuses, you have the opportunity to overcome the resistance. You can ask people, why are you taking this stance? What is going on? Tell me more about what's going on. Why are you not willing to do this or this or this? And you're able to become more involved and ask these questions without the other party being there when they might not want to answer the questions because the other person is there. You can help make the transition for people from the main room to the caucus and then back again by talking to them about how they can broach a subject, how they can talk about something with the other person, how they might want to say it without getting the other person to become defensive. Your decision is who you're going to caucus with first. I always give them both equal time, even if it's just bantering with somebody, talking to them about less important matters, because I believe that if I'm going to spend 20 minutes in a caucus with one and then only 2 minutes with the other, that other person is not feeling that they're really a part of this, and they start to wonder what's going on in the other room, and the trust factor starts to break down. So here's the just a list of what I've been saying, the purposes and uses of caucusing. options that they have, speaking about the options. Sometimes when a party needs privacy to figure out what they want to do, to have a conversation with their lawyer or with you as a mediator. If it's an emotional situation, if the mediator needs to clarify different things, these are all the different reasons why you might want to have a caucus. And one of the biggest one is the emotional venting, giving the parties the opportunity to, vent emotionally in a caucus usually provides more advantages than having them do it in a joint session. They're able to physiologically release the energy that's been pent up, for the last 2 years since this conflict, whatever has started and it's gotten to. You're able to call a caucus just to let them yell or let them cry, to get these emotions out of them, because they're important. You can't just stop them. You can't turn to somebody and say there will be no crying in this room. If somebody is being emotional, you have to allow it to happen, and you cannot ignore it. Certainly, passing a box of Kleenex over to the person is a first step, but completely ignoring it is probably the worst thing in the world that one can do. Most people are uncomfortable if somebody is crying in the room, but just to turn, I've seen this happen. Just one person's crying, and the mediator just turns, looks at the other person, and starts to talk to them, completely ignoring them. Well, that just basically shut down the person that was crying, and getting them back to participating is an extremely difficult thing to do. So the closure, that's the final stage of a mediation, but it's not an isolated incident. These conflicts can have been ongoing for years. Oftentimes they're not going to be able to be resolved in one day, so that you may need to have another day or another couple of days in order to fully resolve, or even partially resolve the conflicts. Don't ignore your ethical issues. If the people are in two separate rooms and somebody has an offer and they want you to make that offer to the other person, your role ethically is to make that offer. Even if you think it's a ridiculous offer, you are required, at least here in Spain and Canada and every other jurisdiction that I'm aware of, to make the offer to the other party. Don't end the mediation abruptly. Don't say because one party is saying that they're going to leave. Don't just say, okay, leave now. And the other party, I'll talk to them after you've left, and they will leave in 10 minutes. Let the other party know that the first party is ready to leave. I ask them always just to wait there in the room. I go to the other room, let the party know that it looks like we're at a blockage. The other party is going to leave. They feel that they would rather pursue this in court, and you give them the opportunity then to make a final decision and understanding that this is it. This is the end. Oftentimes people will say, okay, well, why don't we offer this just to resolve things? And sometimes it's a tactic or a ploy that one party will use by threatening to leave, but oftentimes it works. Even whether it's a ploy or not, when people realize that the end is right here, they decide that they want to make a settlement, and they come to the conclusion that a partial settlement can be better than a no settlement at all. So, just to summarize, I'm running out of time, so I just want to quickly summarize. Your role, very clearly, is to gather the information, actively listen to what the person is saying, get the story, check the story, don't make assumptions. Understand what the person is saying and check your assumptions with them by asking them questions. Encourage them to talk. Encourage them to share with the other party what's been going on and how this has impacted them. If the person shares something with you in the pre-mediation but isn't sharing that now in the actual mediation, you can mention that to them in caucus and ask them why they haven't been sharing this. Obviously, you can't mention something that they shared with you privately when the other person is there because of confidentiality, but you can nudge them in a caucus to bring the mediation or their information out to the other person. Draw out the context, clarify, check your understanding, be aware of verbal clues. I've mentioned this a couple of times. Summarize. Value silence. Silence is really, really important. I find that if I ask a question and the other person isn't answering, I just wait. I let the silence do its job. People have difficulty answering tough questions. And if as a mediator you think that, okay, so they're not answering and it's too quiet, so I'll ask them another question, you've made a mistake. Because they then have two questions and they will answer the easiest of the two questions. And that might not be the question that you want answered. Leave it with them. Allow them to think it through. If you have to reiterate the question, because in my opinion and in my experience, when people are silent, it's because you've asked a really good question. So don't let that don't let that slide. Let them feel uncomfortable, and they will. I can guarantee you that the parties are feeling a lot more uncomfortable with the silence than you are. So leave it with them until they're able to come up with an answer for you. When you are asking them questions, make them open-ended. Don't ask them closed questions because you will get a yes or a no answer. Open the questions up so it's difficult for them to just give you 1 or 2 word answers. That covers off the area that I want to speak about. I think I'm just within my time. I might be a little bit over, but if there's any questions that anybody has, I'm able to answer.
Thank you, sir, for this wonderful presentation regarding the role of mediation. Now, this is the time for lunch break, and we will again meet in the same platform after lunch. Your allotted time for lunch is 25 minutes. We will see you in 2:20.
Quick lunch.
Sir, actually, we are running out of time, so.
Yes, okay. We'll see everyone back at 2:20 as Anindita has ordered us.
It's okay, Anindita.
Thank you, sir.